law, which led to disagreement over money, and the deceased left the partnership. After this, a dispute began between the deceased and accused, and also between husband and wife. Accused then filed a complaint under 498A against the deceased, and current complainant, who is the deceased brother. Deceased brother has not been living with the party since, I'm sorry, Lord, I'm not reading. Deceased brothers has not been living with them for the past 28 years after his marriage, I'm instructed to say. After this, the deceased went to his brother and mother, told them that the accused were repeatedly harassing him, pressurizing him to leave the house he had got in the name of the accused, Rita Ben, his wife, and threatening him. He also said that please allow me to argue. He also said that he was fed up with the harassment from the accused and wanted to commit suicide. On the day of the incident, the deceased sent an audio message in his society's WhatsApp group announcing that he was committing suicide due to the harassment from the accused. Subsequently, when the deceased was admitted to the hospital, his statement to the police, dying declaration recorded by the executive magistrate, and the letter he wrote to his son and all other accused, the current defendant of the harassment. Affidavit from the investigating officer, not my statement, also stated that the deceased committed suicide due to harassment from the accused, that custodial interrogation of the accused is necessary, and that if they are released on bail, it will have a serious impact on society and public trust. Complainant submitted an affidavit stating that the deceased committed suicide due to harassment from the accused and requesting that he be not released on anticipatory bail. Considering all these circumstances as well as judgments, facts presented are not consistent with the facts of the current case as they do not help the accused. Thus, considering all the facts and circumstances, it appears that there is a prima facie case against the accused and the need for custodial interrogation is evident from the complaint. Therefore, it does not seem just to release the accused on anticipatory bail at this stage.
.306 is even if the person says I'm committing suicide because of this, it will not be enough by itself. I was just telling my brother there was another case where I think the wife told the husband, "Jaake mar," and he went and committed suicide. Even then he was acquitted. She was acquitted. Because just merely saying to "Jaake mar" doesn't mean that he has to follow what she said.
This is all a pressure tactic that was being employed on the
difficulty is the abatement of suicide standard is not subjective. It has to be objective. It can't be that a person says, I'm very sensitive, so if I even hear one word of criticism, I'm going to go commit suicide. Then any person saying that I'm committing suicide because of so-and-so, if we start convicting those people on that basis, then it becomes very difficult. You need to have an objective standard. He died, no doubt. But he came to you also. In fact, this is at least a case where they did not ask him to commit suicide. He came and told you that he's going to commit suicide. What did you do about it? Did you send him for counseling? You also didn't do anything. That is their case, that you knew that he was going to commit suicide and you took no steps to stop him from.
Not me, meaning the brother, not
the family. Yes. He came and told the mother and the brother that I
went and lived
fed up with my wife and want to commit suicide. He tells you that I want to commit suicide. What did you do about it?
My lord, he started living with the mother and the brother.
We will grant protection for the time being. Let the reply come. We'll also want to see that dying declaration. Once the state comes, perhaps we will be able to see it.
Very good.
Issue notice to the state of Gujarat, returnable on April 17th September. In the meanwhile, subject to is cooperating with the investigation in FIR endorsement, so the petitioner shall not be arrested. He shall also abide by the stipulations.
Great.
May I please minutes. A closely held company, intra-family dispute. My lords have felt that it will be settled by the mediation. In the meanwhile,
mediation is before whom?
Millets,
J. Prabhakar in
one,
Sorry?
Justice Mr. J. Prabhakar,
J. Prabha.
senior advocate in Hyderabad.
in Hyderabad.
But what are these prayers though? One prayer is to restrain the respondents from
Yes.
creating the atmosphere for
I'll
mediation.
provide the background.
No.
I'll provide.
What exactly are we supposed
See,
to
what
say?
happened?
How are they not to vitiate the atmosphere?
My last
The
game.
second one is even worse. Restrain the respondents from lying to the banks and financial institutions. How do we restrain them from lying?
Millets. With humility, let me submit. It needs to be what you call
What are these prayers, Mr.
It should be modulated, Millets.
Yeah, very-
May I submit one thing, Millets? The difficulty is this,
You
Millets. We are more than
at the
willing to have.
mediation table,
Yes.
and you file these applications, obviously this
No,
mediation
Millets.
is headed
The
for-
problem is this, Millets. In the name of mediation that we have all been waiting, they go about, complain to RBI, complain to Income Tax Department, complain to all bankers who have to lend money to
Finish your
and I've been
mediation, please.
choked completely. Millets, in that context, we wanted your lordship's
There's no
intervention.
point in
Now,
the entire exercise
minutes.
if these are the kind of applications you file. during
May I
the
pray for
mediation
one thing,
process.
Millets? May I pray for you? We have provided all proof with regard to what actions they have been taking when matter has been seized off by your
Take
lordship.
it to the mediator and say that this is what is happening, please.
Kindly see, Millets, RBI has written to them that we can't interfere. Now, Millets, kindly, Millets, let the mediation go on. I'm not coming in the video.
mediation
Millets.
proceedings are in.
No,
progress.
Millets.
We are not
May I seek
trying to
one thing,
entertain
Millets? Now the
This IA seeking.
Millets, only one sentence, Millets, can I add?
Comment. It is for the parties to work out their disputes, if possible, at the mediation table.
May I submit
And
one
not
thing, Millets?
seek intervention of the court during the said process.
May I submit one thing, Millets? Only with regard. Mediation, mediation, Millets.
Is lost
No,
with this.
I'm not on this point, Millets. When it comes to mediation, would my lords kindly appoint any retired
No. Why not? It's before the
judge of
mediator,
Islamic
why
court
should we?
or the High Court?
Why
So
should we
that,
interfere at this stage? How did this
No,
mediator
Millets.
come into the picture?
Millets,
Both of
so
you
far
agree.
nothing has
This
moved.
court appointed.
So far nothing has
This
moved.
court appointed.
This court appointed.
We are not going to the
No.
mediation center.
Millets, mediation center has allotted, Millets, not these your lordships.
Very well.
That's not
Whoever
correct.
it is.
Millets, at least may I pray, Millets?
Senior counsel of that court.
May I pray, Millets? I have no grievance. Only thing is, but could there be a time frame, Millets? It may drag on otherwise. Kindly say that, Millets, it could be 1 month or 8 weeks, whichever way your lordships feel.
Nothing. We are not going to fix
But
that.
otherwise, Millets, they will just have their sweet time. Meanwhile, I could not get loans, I could not run the factory.
Negotiate
I'm the
and
majority
mediation
shareholder.
table. We are not going to.
It's been stifling, Millets. Kindly indicate the time frame.
Sorry,
Millets.
Mr. Naidu. Are you dismissed?
So good. Great. Millets, may we be permitted to withdraw? Anyway, the practice, the prayer is neither here nor there. We'll just have
Having
it.
argued for some time, when senior counsel for the applicant seeks permission to withdraw the IA. Permission granted, the IA is according to this.
Millets, I still implore Millets some time.
After
frame.
dismissal, that's
The time frame, Millets, for the mediation. It has nothing to do with my
not
application.
at all.
So that things will move on, Millets. Great. Deep prayer.
In terms of the last order, the amended memo of parties has been filed. The reply for respondent number 1 and 3 has also been filed a day before yesterday. It might not be on record.
I see, you filed a reply, right?
On behalf of R1 and R3, both are filed. And the last order had directed amended memo of parties to be filed. That has also been filed on the 19th of August.
It may not be on record,
Not filed.
it's filed is.
Joint counsel for respondent number 1 states that the reply was filed on
26th of August.
20.
26th of August, 2020.
26th August. However, we do not find this thing on record. Do you need to file a rejoinder?
Yes, sir, in 2 weeks.
Joint counsel.
R1 and R3 both are filed.
Appellant is permitted to file a rejoinder there.
2 weeks.
R1 and R3.
Yes.
Separate counter or?
Separate.
Separate.
Replies have been filed by respondents 1 and 3. However, we do not find the same on record. Rejoinders that we can be filed by the next secretary. Based on so and so date, registry to verify and put up the replies by the separate. Date should be.
But sir, you need 2
Give
weeks.
you a date. 2 weeks you want?
Yes.
No, before the next.
17 September.
Yes.
21.
Short password may be given. Senior counsel is.
You will have to organize CD player for us because I tried my best to find a CD player. Now, no laptop comes with a CD player. Earlier, laptops at least had that facility. But now CD players are very, very difficult to come by. If you had given us a pen drive, at least we could have seen what was on that video. But you've given us a CD. I tried my best. None of my staff members also could find a CD player anywhere.
Sorry for that, sir.
If you could give us a
Right
pen
away,
drive,
right,
perhaps
yes.
we can
Right.
we can see what is on that video.
Yes,
But the photographs that you filed do show that they are wielding guns.
Yes, my lord. No doubt.
And according to you, 5 victims were shot also.
Yes, my lord. Not a mention of that in the interview, lord.
We'll order notice, but in the meanwhile, give us a pen drive.
I'll do that right away. Yes. I'm sorry for that.
Issue notice, returnable on 24th September. Service shall be erected by all modes, including the SSC. In the meanwhile, copy of the video filed by way of compact disc shall be furnished by way of a pen drive also.
Sir, can I hand it over to the court, sir?
You can file it in.
File it, my lord. Wait.
That's on data. 21, please. 22.
Yes, my lords, the matter stems from a matrimonial dispute. The complainant here is my mother-in-law, who has filed this FIR after 6 years.
Issue notice, returnable on.
My lords, for interim protection.
Returnable on 8th October. Meanwhile, the petitioner shall not be arrested in connection with so and so, subject to the condition that she cooperates with the investigation. 480.
Obliged.
23.
Yes, lords. The Delhi the FIR has been lodged after.
The High Court says that the trial is at a concluding
Well,
stage.
only 4 witnesses have been
And
examined
on
out
what
of
basis
60.
did the state council say that it's at a concluding stage?
No, Malad, that is not correct. Malad, only 4 witnesses.
Maybe
have been-
they will give up the other witnesses. You said there are 11 witnesses, 16 witnesses.
16 witnesses.
16 witnesses. But look at para 7 of the order. The state law officer, as well as the learned counsel for the informant, have vehemently opposed the bill on the ground that 4 witnesses have been examined and the trial is at its conclusive end.
Malad, that is not correct. Malad, they have to come. Malad, since that date, even the prosecution witness number 5 has not come. Malad. Malad, it is not correct. But Malad, may kindly see the evidence on record. I'll show it. Malad, nothing is quoted, whatever is stated in the FIR. Malad, this is a totally false case. Malad, grandparents, parents.
The victim has been examined.
Yes, she has been examined. Her father has been
What
examined.
does she say in her deposition?
Malad, she has agreed that she has not seen any audio or video. She has agreed that he never manipulated my her Aadhaar card. She's kindly see, I can read her statement, Malad.
Which page is it?
Malad,
Oh, read it out, just tell us which page it is.
yes, Malad, PW2, Malad, is on page annexure P8. It starts from page 55. Malad, I just read few relevant papers. She kindly come to page 58, Malad. Malad, she says,
She does state that this rape did take place.
no, Malad, she is saying, but this is not proved, Malad. You never went there. Malad,
Where is the question of proof?
no, Malad, this has not happened, Malad.
When the victim is saying that this
Kindly
happened,
see.
prima facie,
Malad, it is only 120 square yard house, Malad, with the 2 rooms on the ground floor, 2 on the upper floor. Malad, grandparents,
parents are downstairs.
Malad, parents, not only parents, Malad, grandparents, 3 paternal aunts, 3 paternal uncles, and everybody has been implicated in this POXO case, Malad. May kindly see, Malad, that this and all others have been granted bail, Malad. Malad, may kindly see what she says, Malad. She says, I went on my own.
Accused are there altogether?
Malad,
11.
11 grandparents, Malad, a 70-year-old grandparent.
They are on bail, no?
They're all granted anticipatory.
This is the man who was raped her.
Malad, he is not raped her, Malad.
This is what the girl says before the court.
Malad, kindly see no audio video has.
This is what the girl has said in a statement before the.
There is a
This is
question of
during
non-
COVID period, Malad, at night she says.
Once the victim says that
So
you
no rape took place during COVID.
Kindly see, Malad, is it?
What is this?
This is
What kind of statement is this?
Malad, COVID period, Malad, at 9 o'clock, Malad, in the month of February,
She
she.
has named you, she has stated everything about you.
No, Malad,
It
but
is not as if during COVID period, nobody was coming out of the house.
no, Malad, then Malad, she could have entered, then she went, Malad, she.
At this stage,
Medical.
we find no
evidence
good
also.
ground.
People,
Sorry, we are not disciplining.
Malad, may kindly
We do not-
expedite the trial.
Any good ground
That has been done by the High
to
Court.
interfere with the.
Last paragraph.
So as the High Court records that the trial is at the state of conclusion, the special petition is accordingly dismissed.
Seeking anticipatory bail, it's a false case.
Details of that complainant,
Furnish the detail of complaint.
the complainant who's given that affidavit.
It's there, his affidavit is there, the details are there.
Details are also there.
Yes,
Will
but
not impede him as a respect.
just a second.
You'll have to give the details
This
otherwise.
page 17.
But the address and all.
Well, this village,
The
village,
FIR, his address is furnished.
well, this says, I'll read it, madam. So and so, son of.
But we've already read the affidavit. We need his address. Where do you get the address of the complainant?
Well, some better address, if it is there, well, village name, post office name, in villages, it is like this only.
Name. So and so. We'll find the address also.
Yes.
Is indicated so motto as respondent number 2.
Yes, sir.
Issue notice to the respondents returnable on 8th October. Exception and solution benefits are almost including vesting. Well, in the meantime, the petitioner shall not be arrested. in
Yes.
connection with the file number so and so. Subject to this cooperative
I'm so grateful.
investigation.
I'm so grateful.
25.
Can I indicate what?
Same condition you comply with in the state of Jharkhand.
I have filed that additional documents is not on record. Would the lordship?
Grading scale ISO certification,
No,
how can you have an objection to
It's
that?
in practice also.
Not that, it's not
It has
that.
been opened now, but 3 parties have filed notice.
Not that, this is not my objection. Can I indicate what is happening? Lordships will see the nature of supplies. Please have page 130 of the paper.
130.
Yes. What has to be supplied to a centrally sponsored scheme? Just have a look at what has to be supplied and what 130. Because 30,000 such kits of bat, ball, watches, batons, tops. This is the supply which has to be done to 30,000 schools all over Chhattisgarh. Large number of items all over the schools in India are to be supplied by various vendors.
Very.
What Chhattisgarh says is, you must have supplied to the state of Chhattisgarh in the
All
past.
those have been changed.
No, Milos, that has not been changed, Milos.
But the High Court.
No, Milos, it has not been changed.
That's
No,
why-
not at all. Let my learned friend says that.
Then why didn't you argue it? before?
Because we argued it. The High Court says we won't interfere with the tender conditions. Because Lordship may take it from me. This
There is a specific paragraph
no,
in the
no,
order
Milos, that has not been changed. That's the
which records that both
No.
the Learned Council agreed that this is the.
no, Milos. That's not. That's why. Just have a look, Milos. Where Lordship are reading which page, Milos? The Chhattisgarh part remains. I am disqualified today.
Out of 4, 3.
Just 1 second, sir. Don't do this, please.
Some paragraph where.
Which says, Milos, please have page number 13, para 11.
Page number 13.
Para 11.
4 conditions, it is.
Pursuant to
pointed
which
out.
3 of the impugned have been amended. The challenge arise which forms subject matter of these 2 writ petitions. Which is this?
This is not disputed by the Learned Council.
So which is this? This is part of state of Chhattisgarh. That 2 words. That is the 4th condition is page 119. Bidding condition, Milos.
No, the 4 conditions are extracted at page 7.
Yes, my lords.
The fourth condition is all that survives is what is noted.
Yes, my lords.
Fourth condition is with regard to
My lords,
ISO,
I think-
NCDSCO.
My lords, that but apparently the High Court has put it that the fourth, but there are totally in fourth, it may not be chronologically the fourth. If the state says out people who have supplied to other states are welcome, I have no difficulty, my lords. The difficulty today is 3 people have been supplying to the state of Chhattisgarh for years.
Yeah, but can you see paragraph 18?
I know, my lords. Para 18.
Because para 18.
Yes, my lords. That's why we have filed additional documents last night. It has not come on record because yesterday was a holiday.
Please read para 18.
Yes, I can show Gujarat, which is on record. It says that similar states have other conditions. Lordships, this is exactly what your lordships are referring to.
Yeah.
Please see the state of Gujarat at page 63.
No, what about Jharkhand, Delhi?
That we have also filed, which have copies.
You obtained a contract in the state of Jharkhand.
Jharkhand. So I am from Ghaziabad. I would not be able to get a contract in Jharkhand, my
No,
lord.
this is, the respondents have demonstrated that such conditions are not unique to this state.
Because that is-
weighing scale.
And the petitioner himself has successfully participated and obtained
Let's-
contracts.
Can I therefore say, because without taking the lord, it's not weighing scale, my lords. It's not weighing scale.
Condition, Joe.
Yes, my lords.
Past performance.
Yes, my lords.
Bidders must have supplied at least 6 crores to the state government.
Yeah, of Chhattisgarh. Yes, my lords. Not to other states.
This is what they insist.
No, this paragraph says it's similar condition supplied.
Take
This
it.
is in reference to that.
Yes.
This is in reference to this
But it
condition.
doesn't
Yes.
say so.
But it has to be because if you look at it in Jharkhand and this is applied to Jharkhand.
Yes, you have supplied to Jharkhand
I have supplied to Jharkhand. I have
Earlier.
supplied to Tamil Nadu. Yes.
earlier.
A large number of states.
Please, one by
Yes,
one.
Manoj. Yes.
And in Jharkhand, also there was a condition that in case you have supplied earlier to Jharkhand, you
Yes.
will
Oh, yes. Manoj, can I place it on record? It was yesterday was a holiday, so we couldn't come on record. So I don't want to take your lordship's
So
time.
Jharkhand didn't have a similar condition.
No, and Gujarat we have placed on record. Lordships will mention Gujarat here also. Lordship sees Gujarat is also written here.
No, but why are you limiting it only to local people?
Because Chhattisgarh has a unique situation. We have natural infested areas. The projects, the supplies have to be taken to in 60 days. In all of
But
these.
why
5,
only
5,
local
0.
people?
Because not local people.
Not
because
local.
You are saying that unless you have supplied to state government.
No, because that's absolutely incorrect.
Chhattisgarh.
No, because
That is one of your conditions.
one of the condition is that they must have had past experience, not local people at all. I'm so sorry.
Where is the amendment
Because
of this
these,
condition?
no, because it's quoted in the impugn order itself. Because
Because what my learned
please
friend
see,
wants
I'm
to
so
say.
sorry, because allow me to clarify. Please don't do this. Because my
He
point.
said that to you,
Well-
just saying that you say it to him.
and you rightly said so.
It's welcome to say.
Because the condition is not that you must be registered in Chhattisgarh, you must be Chhattisgarh company. No, not at all.
This
Because
condition at
there was previously a
page 6.
Condition is that in case you have supplied goods earlier to Chhattisgarh, then only
Yes.
you can.
What- then you're in-
absolutely. I've fought on this. Only when you have experience with Chhattisgarh, you may be
Why?
tender. No difficulty on that. Because Chhattisgarh has scheduled areas, because where tribals are there, because then they have natural infested areas.
How is that relevant?
That is relevant because
These are sporting machines that need to be.
Yes,
supplied
absolutely,
to-
because it is not easy to deliver those in those areas, because they are dense jungles. We need to show some past experience of dealing with those areas. There are animosities, there are attacks, there are law and order issues, because my reply is not on record. Please allow me to show, because all of this was there before the High Court, because. And they run it in Jharkhand, and it fell from my lords, absolutely right. When this condition is favorable to them, they win in Jharkhand. And now, my lord, they are the ones turning around and saying they don't even apply for tender. Now today the tender is open, my lord, 3 companies have won it already.
Those same
The-
companies which
both
are
the
continuing
technical
for years,
and-
Milos.
That's not the ground, Milos. Where is the
No,
ground?
no,
Where is
I've raised the ground. It's all oligarchy. It's all oligopoly, Milos.
At least that much discussion has to be there to the state, Milos.
Of these conditions,
Man.
which is what is referred to in that
Yes.
page 13,
Yes.
19,
Yes.
not 19.
It's page 191 is the amendment.
Where is it?
191. This clause is not amended.
But why did your counterpart agree that?
Because that's what happened. No, Milos, that what happened. Fourth condition, what High Court intended to say was this state of Chhattisgarh supply.
No, that is not how it is.
Milos, that
It extracts
I know
condition
that,
number
Milos.
4
Yes.
and then says,
Milos, but
and you agreed to it that only condition number 4.
my learned colleague appeared through VC. Here, the matter came up on one first day. There is no reply even called for by the state. From the state, sorry, Lordships are reading something. Can I?
91.
191. So Lordships will see this Chhattisgarh part is not amended. Lordships will see that technical qualification of a bidder is he should have supplied to Chhattisgarh in the previous 3 years is not been amended. Weighing scale was amended, that CDSOC was removed. So weighing scale part below is a different issue. Today it may not arise or arise, that I'll address your lordship later, but the main grievance is about that outside state people are not allowed, or people have not supplied to Chhattisgarh, can't apply.
I'm sorry to intervene, because that's not correct, Milos. I'm just saying past experience. They may be from Kerala, they may be from Karnataka. If they have past experience of dealing with that topography,
They will never have this past experience.
yes, they have, Milos.
No. If you're not permitting them to enter the state of Chhattisgarh
How will
with
they
a condition like this, they will never have this past experience.
came up with this
Previously,
condition only
there have been
recently.
who are from
So
outside.
there's a cartoon of 3-4
Yes,
people
Milos, yes.
from the state of Chhattisgarh.
Correct.
They have the past experience
Right.
and they'll continue to
Milos,
have that experience.
that's not been argued, that's not the case. But
What is arguing?
It's not even there.
This is what your
That's the
analysis
first step
says.
they're putting there.
This is
We
what
are
your
asking
analysis
you,
We asked you.
how,
That
the way you have fashioned it, there is no possibility of any outsider coming in because you've already got this condition.
Milos, if
There's no question of getting their past experience.
no, Milos, that may not be correct. Milos, my humble submission.
Why did you come up with this condition only recently?
No, Milos, what's happening?
From when have you had this
I need to
condition?
take instructions. I'm not aware of.
And the concept of 1,000 crores, you are doing all this.
No,
No,
it's
but it's
15
not
crore.
1,000 crore.
But it's for bad and all.
60 crores.
15 crore.
Notice, file your reply.
50 crore, roughly 50 crore, sorry. Yes.
At this stage, perhaps,
Milos,
no
I can't.
interim order,
No interim order.
but we will at least test their bona fides and see to it that they don't do this.
Milos, can I do one thing? Milos, can I do one thing? Lordships may interfere or not interfere is totally your lordships. I can give my tender, let the financial bids come, then your lordships will see that.
opened it.
Open
No,
it.
the financial because it was not
open. That chapter is over.
This is kind of
I'm sorry.
a from the state.
You've
Milos,
not even submitted a bid, is it?
because it didn't take it. Because I was not
At
from
this stage, where is the question of allowing you to submit a bid after the opening of the financial?
No, financial bid, management make a statement that financial bid is open.
I'm instructed to state.
Let the management make a statement.
Alright, so we'll direct status quo.
Status
It has
quo.
not been
Yes,
opened, it
Milos.
will not
I'm
be
sorry.
Grateful.
Very good.
Very well. Status quo may be preferred.
So notice return bill on 24th September. Meanwhile, status for obtaining a today shall be meeting, but as this affects the pointers concerned.
My learned friend takes for both state and the Samagra Shiksha.
Because I'm only instructed to appear for the PSU,
Yes.
not for the state.
The Samagra Shiksha.
Trips notice. On behalf of respondent, waves for the service.
Just to avoid,
Be affected upon these.
but just to avoid confusion, I am limiting my that to as Chhattisgarh. Lordship may next time again it shouldn't appear. That's why I am limiting my submission that people who have participated in the state of Chhattisgarh earlier tenders are allowed. That's all. That may be a confusion. My learned friend appeared through VC, so maybe he couldn't understand what is happening at the point. That's what he told me yesterday. Grateful, dear Lord.
Well, it's untrained teachers teaching presently in West Bengal.
Yes.
Item 26, my lord. Two issues on this, my lord, which your lordships heard in the morning as well. We have explicitly said there is no sifting mechanism. They are
That we
allowing.
will verify.
Yes.
At this point, stalling the process doesn't.
No, we're not asking for stalling. We're
So
taking the
we will
exam.
verify once the exam gets over.
Yes.
If you're able to show us that even a single tainted candidate has even been allowed to appear, whether they're selected or not is a different issue. If you have the list of details of
They've
who
not
appeared,
published the list, my lords.
no, that list is one thing.
Yes.
The people who appear,
Yes.
all that you will produce before us.
Yes.
We will
Because
take the
maybe we-
CBI in case you tamper with the tainted candidates list also, not to be trusted. So perhaps we'll have to bring in the CBI so they share with us directly the list of tainted candidates.
Candidate list has been published.
They're not.
That is,
published.
and only
No, my lord.
small,
Even in the other matter, that was the same.
what that kind. We have given after your lordships, when your lordships have passed the order, that they will continue up to 31st December. In every places, we have sent the names of only the untainted teachers.
Then they should file with your my lords.
No, but
Kindly allow me. Untainted teachers are.
High Court judgment required you to put it in the public domain. The
That is
list
regarding-
of tainted candidates. We have not interfered with that direction. So that direction still stands.
Yes, yes.
Have you put the list of tainted candidates in the public domain?
Yes, Milord.
Have you or have you not?
Even in an affidavit.
Yes or no?
Yes, yes.
No, my
Yes.
no, my lords.
Yes.
No.
Even in an affidavit.
Where have you put it?
Milord,
Website of? Website, newspaper, how did you put it in the public domain?
Milord, I have been told that 952 persons' names have not been published.
Why have
That
you
is
not published?
untainted. Untainted.
No, tainted.
Tainted names have not been published.
Why?
That names have not been published.
Why are you keeping them secret?
But sir, with due,
No, there is
sir, with due respect to you, what kind of advocacy is this? I mean, your first sentence is something and then second sentence is something. Earlier you were telling us that yes, list has been published, it is on the website. Now, just after a few seconds, you say no.
I'm
it's not.
sorry, Milord.
But just by saying sorry, I mean, this is what I'm seeing all this in Supreme Court only.
Milord, untainted.
I mean, we trust you for this.
Milord, untainted teachers, we have sent the names to
We
them.
are again and again telling you that we are not talking about the untainted teachers. We are talking about the tainted selected candidates whose names were directed to be put in the public domain.
Milord, we publish the names within 7 days.
And this we will record. Then you are appearing for the
I am appearing for the SSC, School Service.
Learning, Senior Standing Council appearing for the West Bengal Senior
School Service Commission.
Service
Central School Service Commission.
Secondary School. What is it?
Central School Service.
Central
School Service Commission.
States on instructions that the list of tainted candidates who were selected and whose selection has been set aside by the High Court and confirmed by this court would be placed in the public domain.
In the website, in our website.
That is on the website of the commission within 7 days. We take this statement on record, issue notice, reply, issue notice, return.
But only one thing I have to say, Milord, here. In this case, all the petitioners have made their applications.
Well, let them
and they have got their admit cards.
Let them appear.
7th of September and the 14th.
Let them
of
appear. List on 8th October. Reply, counter affidavit if any. Don't say if any, counter affidavit shall be filed by the contesting respondent within 2 weeks, 3 weeks. Joined thereto if any, may be filed within 2 weeks thereafter.
No other order.
So we also have an
No orders in the line of
This,
debate parliament.
very well, we will also record that you are saying that they've already submitted.
Yes, yes.
You need an order otherwise? Do you need an order?
No, we have.
Learned Senior Counsel appearing for the commission further states that all the petitioners have already submitted their applications and that they would be permitted to appear in the examination scheduled to be held on 7th September 2025 without insisting upon their meeting the enhanced eligibility criteria as per the rules framed in the year 2025.
But 7th September and 14th September.
7th
9, 10,
September.
7, 11, 12, 14.
Sorry?
9, 10,
Oh.
that's 7th September.
7th
11, 12.
11th, 12th is 14th September. my lord.
7th and 14th.
One.
My lords, we also have an application for deletion of some pro forma respondents from the High Court, my lords. That may be allowed, my lords.
Which one is that?
This is 207659. I 207659 of 2020. It's just a very. Yes. Yes.
Amended memo of parties should be filed by the.
Yes. And my lords, if they don't publish the list in a week, my lord, we'll come back to you, my lords. Yes, your lordships are monitoring. But I'm so grateful.
I'm accepting notice on behalf.
Mr. So-and-so, then Councillor, give your name, please.
And it's, I'll also accept it for the commission because our cabinets were not filed. They come
Very
directly.
Milord, this, whatever I have said, Milord, as a 7th within 7 days. As a council, I am saying it should be published. That's the reason I am saying.
On instructions, we have noted this. Vivedi told you that you would be doing it.
But we have not published the.
Do it within 7 days.
Yes, sir. That is an acceptance. That is an.
Grateful minutes.
27.
Confuse your options. Bank is caught in this crossfire. No, the problem.
It's an order of the High Court. Where is
No, I know.
you're being caught?
No, no.
What is your local
Trial court. The trial court, what I.
High Court now directs you to release the amount to him.
Well,
This is a
it's
High Court order.
Okay.
It has to be blamed. It will be the High Court.
2 minutes. The
And
bank.
these are not even Parvinder Kaur's fixed deposits. These are his own fixed deposits.
That
You
is not
committed to the
converted.
reversion already.
No, that was because we were not aware.
Committed to the reversion.
The file.
So these
What should
two,
we-
these two fixed deposits stand in his name.
2
Who are
minutes.
you to object?
2 minutes, just two. There's a consumer complaint against me. There's a criminal case I believe has been filed against me. The bank is getting involved.
Therefore, you are withholding his amount.
No, I'm not with in case, initially the
Then
money was
before all
released.
this happened,
The
you could have
trial-
filed an interpleader suit.
No, that's what the
Why
application
did you
almost
do it before all this?
application at page 79 is almost in the nature of interpreter where the trial court would say that give 20% now, the rest will be kept to the credit of the account.
Now the High Court says give the whole thing to him.
And there's a contempt now against me, my lord. Today at 12 o'clock. I've been told to appear.
What's your look?
No, the only thing the High Court could have been careful saying 45.
If the High Court has directed you,
Yes.
where is the question of
No,
anybody holding to account?
said 45 ZA4 because then the consumer company will also dissipate. I am stuck in this, Malas, unnecessary litigation.
You are not stuck in it.
Money.
You are just
But I have to defend the consumer company.
overthinking the whole issue. There's a High Court order. Who are you to doubt
that's
it
right.
now?
So, Lordship, take.
You are bound by the High Court order. There's a question.
If the High Court would have
Complying
said
with the High Court
45 ZA4, I would have been protected. It's a very open-ended order. They will still be at my throat in whatever form, my lord. If the Lordship can put 45 ZA4,
You ask the High Court to clarify.
then may I then request one thing, my lord. Today at 12 o'clock you are supposed to appear. Can I take it?
It's 12 o'clock now.
No, but I have to give a commitment. I have to do it, my lord. Lordship, can I take the order at 2:55?
12 o'clock now.
Page 2:55. That's
The matter would have been called.
Officers have been called there. Lordship, I will contest.
Comply, please.
I will comply. Give me 6 days time to comply.
No. You do it today itself.
You go before the High Court and say that your SSC
No,
has
no,
been.
this is, I think it's a clash of ego.
No, not the bank. What is bank?
Bank only.
Bank, what is the bank got to do? My money doesn't come to me in any case.
It's the money.
You have control of the money as long as the fixed deposit is there.
They will make a fee. It was made in our bank itself.
If you were really serious, you would have filed an interpleader suit immediately.
2:55 for a
You
minute.
don't do that. You hold on to the money.
Very well, man. I take what you're asking. 2:55 for a minute. 2:55.
We are not going to.
No, Lordship, can you give me some time? Extend at least till the end of the day.
You want to wait, I can do it.
Then could you also exempt the petitioner, these the officers from
Let them appear. They should know what.
If somebody else's suit, Malas, I am caught in the crossfire, Malas.
Because
Could you Lordship
it-
permit
There
this
is an
thing to
order
happen?
of the High Court and then
No,
you.
I know, but so I filed the SLP, Lordship will extend that time.
No,
Lordship
very sorry.
does
Very
it.
sorry.
We are not inclined to interfere with the issued order passed by the High Court, especially a petition.
Okay, very well, Lordship will record my statement, will comply, exempt the ED to do it.
Make
Go
it, sir,
before the High
make
Court
a
and say
statement
what
before the
you
High
wish
Court.
to.
Well, this is, it's just one sentence from your Lordship, can you see? The ED has been directed to appear, Manas, personally. Lordship, can you?
Yes, that he must appear. That's the, for ED only,
That's again an.
Not the ED.
That is
Again, we directed.
This is
Ego issues. There's nothing wrong with
ego issue.
Ego of the bank, we have said the very first
whoever
day.
the person is,
And
there's
there's nothing to
no
do with
loss of reputation merely because he appears before a High Court.
You can file an litigation before the High Court.
Now we don't have the time, 12 o'clock, Lordship, can you, end of the day, at least at the end of the day, comply.
Go ahead.
Directions are not going to say anything at all.
Well, I don't mention.
48, sorry, 28. Receipt of 41A notice.
And I gave a reply.
Unless license will be recorded, there's no question of arresting him.
No, my lord, but now that the Honorable High Court has dismissed my bail application,
That is, you're unnecessarily invited there.
I thought as much. But then, Lord,
Then
there must be some
once
real
you
apprehension.
dig your own grave, then you can't say that I won't fall into it.
But Lord, perhaps they have not either seen my reply or
And we've also got details of your past antecedents.
Lord, all of
or
that I
pending
brought a charge.
antecedents.
Mostly 138 I have brought a charge, Lord, somewhere acquitted, somewhere convicted, and Lord, some are on the
Which
company.
page is the list of old cases or present cases?
That list your Lordship will find at page 3, Lord, High Court order, bottom.
No, there's also a separate list filed, I think.
3 bottom, Lord, is the list which the Honorable High Court has listed up.
15 cases.
3 bottom, Lordship.
So all these cases.
Serial 3 to
138, 140.
Serial 3 to 13 are all 138.
In any event, if the officer wants to arrest you, he'll have to record reasons. So,
But what I'm saying is this. Please have the FIR. Please have the FIR for a moment. Now, my lords, this is the
5.77 crores
no,
between
14 lakhs.
2018 and 25.
14 lakhs.
And all withdrawn.
14 lakhs.
5.77 crores.
Lord, please have this FIR. I'm only in one FIR. Paragraph 7, yes, Lord, because there were 3 FIRs.
5.77 crores.
There were 3 FIRs.
All withdrawn.
There were 3 FIRs.
Where has all this money gone?
Lord, and I have supplied the goods.
Where? No laptops, nothing, no cycles.
Therefore, I am saying, Lord, just bear with me. Just bear with me. These are 3 FIRs. Today we are in one FIR.
Definitely not a case for anticipatory.
But Lordship may have page 21 for a moment. Lord, can I show the mechanism by way of which this is being done against me? Please have page 21 for a moment.
21.
Because that's the unilateral say that they paid money. No doubt I received money. Please have 21, Lordship, see not clause 3 of the FIR. 3A, occurrence of offence, cheating day, not mentioned date from 2018.
That's all right.
Now, Lord, it's been 7 years.
Your bank account shows that you received this amount.
And I supplied the goods.
Where is the proof of supply?
I have given in my 41A reply. Please have my
Where is
reply
the proof
41A.
of actual supply?
No, they have given my.
That you have supplied so and so.
I have given with my 41A reply to the IO.
Show us the acknowledgement.
Lordship may have it after 1 week, Monday. But please have page 20.
Filed it, that obviously doesn't.
So please have page 25 minutes for a moment.
We expect
page.
all relevant documents to be filed.
Lordship,
That are not filed.
I am told
we are not going to allow you to build up the case taking a cue from us.
But only page 25 for a moment.
25.
If that impresses your
Where is
25, please have para 5.
Yes.
Attached is the copy of invoices of products that we supplied to St. Anne's Group in Ranchi and St. Anne Convent Mandar and St. Anne Intermediate.
Why have you not filed copies of those invoices?
No, what has happened is my learned friend filed it because it was urgent and it has come up because registry at times becomes over efficient. Lord, give us 1 week.
Sorry, we've already told you we don't allow this building up of cases.
No, but Lord, invoices, whatever I have filed,
with the improved judgment, especially pensioners according to this.
Then would your Lordship kindly oblige us by saying that since the 41A was given, he will record reasons.
Section it says so. Why do you have to read?
High Court Lordship gives that one sentence the initial observation.
No more nudges or pushes.
No, my lord, NDPS, no possession, my lord. And
you were supposed to receive it, though. You were supposed to receive this method.
that is what the case is, my lord. But he did not receive. It is only on the basis of the statement of the court.
5 past cases.
My lord, out of 5, I'm acquitted in 4. And my lord,
acquittal doesn't mean that the case stands wiped out. You do have 5 past cases.
My lord, it is all 323 and my lord 504 cases. One NDPS, my lord, and that is similar kind of case where they have
commercial quantity, no question of granting.
My lord, it's my lord only statement of the co-accused. Except that there is nothing, my lord. Statement and my lord. My lord, anticipatory bail. I have placed certain orders on record. If my lords, my lord, can peruse that. Please see in the compilation of documents.
Which page?
Which this is, my lord, page 8 in the compilation PDF, my lord.
Page 8.
Page 8, my lord, in a separate compilation, my lord. There is one additional documents and the other compilation, my lord. Page 8, my lord.
Compilation or the additional document?
No, compilation, my lord.
This
is similar case, my lord, wherein, my lord, there were antecedents and the court said learned counsel for the respondent state has vehemently opposed this petition on the ground that there are criminal antecedents against the petitioner. He is also involved in 4 other NDPS matters. This court-wide order dated.
was only making the order absolute. So let us see the other orders that you have.
Milord, the first order is at page 10, Milord.
Page 10.
Page 10. The first order. Issue notice and then para 4 by way of ad interim relief in event of arrest is directed to be released on bail, executing a bond of so and so. Needless to state that the petition.
This case involve a commercial quantity. There's no mention of a commercial quantity.
Milord, it is not there, but I'm told yes, it was, Milord, a commercial quantity.
No, we don't trust. I don't trust myself.
Milord, may I just place that on record if my lord thinks.
Bail orders, NDPS matter, bail granted. So in this case also NDPS matter, bail granted, please grant the bail. What kind of power, sir?
I'm only saying, Milord, that it is ultimately on the basis of the statement of the co-accused.
Anticipatory bail. That's it.
Milord, it is on the basis of the co-accused statement, Milord.
No anticipatory bail.
Especially petition is accordingly dismissed.
Very well.
Lordship, this is a bail application.
Very dangerous. Very dangerous.
Has to be heard.
Hello, there's a bail application.
This is a bail application. 12 have been.
Notice the earlier order.
Lordship, yes.
Please see the earlier order. Several people have been granted.
13 people have been granted.
You were not given the same relief. Perhaps for a reason.
Because I have a chart with the allegation against these applicants.
Yes. That is there. Lordship, the court records.
Why this distinction was drawn between you?
I argued on the last occasion also. Because it's 11 years that they are in.
So we'll give you a date and hear the matter. The matter is ripe for hearing. We're not inclined to entertain the application for grant of bail pending discipline at this stage, as the matter itself is ripe for hearing. The IA is accordingly dismissed. List the appeal for hearing on 8th October.
Obliged.
The passwords are there.
No password. Petition, man.
Before the other side starts, just 2 minutes, Lords, I wanted to mention something. Your Lordships had asked us last time to file the Your Lordships had asked us to file the report of the.
We have a compilation.
So, Milord, I have filed. Can I just take your Lordship to just 2 or 3 pages of that? This is I-8-208-681.
Yes.
Will your Lordship straight away come, Milord? To Milord, so the report starts at page number 8. And then, Milord, there's a detail given about how various parties gave. My Lord doesn't have.
Below this one.
Yes.
Lord, if your Lordships have the idea, the report of the independent engineer starts at page 9 and the consideration really is at page 11 onwards. I just read 2 pages, 2 paragraphs.
Yes.
So 3.1 at the top of page 11 are staircases. So there they said there are 2 staircases, main staircase and fire escape emergency staircase. So these are the 2 that are considered. Now, Lord, if your Lordship just comes to the paragraph which reads after close inspection, the 3rd paragraph from the bottom. After close inspection of the staircases, we have observed that many treads, both in the main staircase and fire escape staircase, have been damped and repaired with patchwork. We have come to the conclusion that patchwork staircases certainly present an unseemly sight. We gave careful consideration to this question and applied 2 tests to determine whether this is acceptable. One is specification test, second is quality, consistency, and aesthetics test. Then, my Lord, the test is mentioned. And after that, my Lord, is yes, correct. In fact, my Lord, may I read the specification test? According to specifications, clause 4.4.4 code, main staircase will have granite tread and riser, and fire escape staircase will have quota finish work, unquote. But for some reason, builder has used granite in both the staircases. Very well. Then, my Lord, the main staircase is dealt with from 3.2.1, and there, my Lord, the finding after applying the specification and quality aesthetics test starts on the 3rd or 4th para, which says in a prestigious if your lordship is in a prestigious. Basement plus 11 upper floors IT park claimed to have been constructed using state-of-art technology. Such patchwork stairs are not acceptable as it is aesthetically in harmony. It is not aesthetically in harmony with the requirements of such a building. We have found 98 steps in the main staircase with patchwork or unacceptable level of damage. We recommend that these 98 steps of patchwork should be replaced by builder with good quality granite slabs of matching color. This is one problem according to them, and out of 2 lakh square feet of construction. And then so far as the fire escape staircase is concerned, which is the next one, there the very last line says, we have identified 29 steps in the fire escape staircase with patchwork of unacceptable level of damage. 29. And the next line is, we therefore recommend that all 29 treads in the fire escape staircase should be replaced by the builder with good quality granite slab. Although it was supposed to be quota, but he's also said granite slab of matching color. And then fire safety system, there is absolutely nothing which says that has to be done.
What is the date of this report?
The date of this report is, my lord, May. And there at the very last paragraph it says that the landowner stated the structural consultant should certify the strength and stability of the slab. Accordingly, builder produced a certificate from structural consultant which appears to be acceptable. I in fact got a structural certificate also.
That's 32. Item 4.
Yes, no.
8th floor, all the staircases in the respondents' constructed area have broken. Please refer to Annexure 3.
Yes.
Where is Annexure 3? That's this one.
Annexure 3.
That is not 5.
That is, no, it is, I believe on.
This is Annexure 4, I think it's, yeah, this is.
No, Lord, I believe that what is Annexure 3 is actually the report that your lordships are reading. But what it probably means is Annexure 4, which is at page 29. So that might be a typo, Lord, I feel.
Page 29.
Because Annexure 3 is 21, so it can't be this can't be the Annexure. So 29 is Annexure 4. These are the details of the steps. I believe this is what is referring to.
Nice.
It's just a typo when he says Annexure 3. I think that should be there. So as I said, 98 plus 29.
All these have been replaced.
Yes, bro, according to us, we've done everything. And suppose even on that small issue, to think I'll do it even now. It will be 98 steps. And then we've got the fire certificate. Then your lordship, he's also filed some photographs starting from page 33 onwards. By the architect, these are not my photographs. So your lordships will see this was the position in 2011 of the building.
This is part of the report.
Yeah, part of the report. This was the position in 2011. Your lordships will see page 33, 34, 35 chiller plant on the terrace, pumps, insulated pipe connections on the terrace. This is a fully complete building, page 35.
Yes.
Then also now what the defects in the staircases were, your lordships will find at page 50, 47 onward. This was what he's referring to. This is the defect. He said because what had happened was that the staircase was put up. Then some material was taken up and down, so some of it
after your repair, perhaps. Because it's
this is pre-repair.
Pre-repair.
Pre-repair. This is according to him aesthetically correct. Post-repair. This report will not have it because obviously this is. But
you replace the entire stand.
According, I'm instructed, but suppose we
The fans on?
It would be very
Them are
helpful.
on.
It will be very helpful. Please. I think they don't put it on because of the sound. And it
But
might
3 are on. This one is switched on. Oh, the others are all on. Okay, this one is.
That's the problem with the centrally central because if top person doesn't like the top,
No, I'll tell you.
he'll say put it on 26. So it has to be on 26.
But especially people with my problem have a problem with overhead and cooling.
Lord, I've taken instructions on that. In fact, so this is the correct position. Is this was the objection at page 47, which the architect found, according to which the independent engineer found. My learned friend tells me that whether we did it or not, at this point in time, we are not very sure. But it's only 98, and either I'll pay for it or do it even now. There's no big problem here. Then there is some, and these were caused because material was being taken up and down after the staircase was put. Therefore, they got chipped at various places. There's nothing very major about it. Then and there are 3 lifts in this building in any case. And then lastly, the page 67 are the photographs of 2011 April. 2011 April. Sorry, sorry. This is 2009 April. The affidavit says so. This was the position in 2009 April. Page 67 on. And that includes the inauguration of the building. Right. So we've taken instruction from inspection report. Okay. This is what it was.
Yes, Mr.
These are your own photos.
No, the inspection of the report.
No, 67 onwards are not our photos. Before that is part of the report. Correct. That's right. You're right. Yes.
Main please along.
Yes.
I had a lot of arguments from my learned friend about what the condition of the building was, etc. Unfortunately, what has not been shown to my lord is.
Have you done anything about the steps in the meanwhile?
I have done, my lord, even after 2010, what is shown in the
For just a few minutes,
was because I was put in possession in 2010 and I did it.
Get these steps repaired?
I did it.
You've not filed pictures of it.
I'm not, because my lord, that was never the issue. Let me explain.
Now we're asking.
I'll do that certainly. Your lordship's asked me anything, but please, my lord, this is an arbitration proceeding. It's neither a 226 nor is it a civil suit. So your lordship's recent judgment, where my lord was a member of the Constitution Bench, and earlier judgments, my lord justice has clearly said that the arbitrator cannot decide anything which is not referred to him. What has been pointed out to my lord is what is the present condition of the building, what was the then condition, what was the condition on X date, what was not the condition of the building. We are having a new argument on facts about what is the evidence, see these photographs, see these photographs. No, that was not referred to the arbitrator. Please see what the reference is. The reference was never how much more needs to be done for the building, is it minor, is it not minor, that was not the reference. Pure and simple, the reference was this. Please see page 35, impugned order, shows your lordship what the reference was. And if the arbitrator decided beyond the reference,
page 35.
35, if he decided beyond the reference, your lordship will strike it down. You have said he can't A, go beyond the matters referred to him. B, he cannot give reliefs which have not been asked for. Please see what are the reliefs. This is not an action for specific performance. This is not an action for anything else. Please see what the action is. Page 35.
Yes.
What's most important has not been shown to my lord. What is the claim? What went before the arbitrator has not been shown to your lordships. In the arbitration proceedings, first respondent company filed their statement of claim, claiming the following reliefs. To direct the appellants to jointly and severally pay the first respondent company, that is for me, to pay them a sum of 5,92,000, 5 crores, being the refundable security deposit together with interest at 12%, future interest at 12% on the sum of 4 crores 82 lakhs from the date to the date of realization. To direct the appellants to jointly and severally pay the first respondent company a sum of 1 crore 21 lakhs towards rental deposit, caution deposit, etc. To direct the appellants to jointly and severally pay to the first respondent company a sum of X. To pay the first respondent company a sum of so much D. To direct the appellants to jointly and severally pay future maintenance charges at 3 rupees 50. To direct the appellants to jointly and severally pay them a sum of 4 lakhs 86. To direct them to pay future electricity charges, to pay service tax to direct the appellants to pay the sum. And the entire prayer is only this and K. To direct that the first respondent company is entitled to the original of the power of attorney dated 29/3/2006, executed by the appellants. This is what they went to arbitration for.
Where is your counter?
Now please see, my counterclaim is found at page 38 at 39.
Yes.
To declare the various sale deeds dated 19/12/2008, registered in the office of the SRO Malapur, Chennai, allegedly executed by the first respondent company to an alleged power of attorney as illegal, void, and not binding on the appellants, and to direct the first respondent company to deliver the sale deeds for being cancelled and authorizing the appellants to execute appropriate cancellation. To declare an adjudged release deeds dated 10/11/2008, executed by the first respondent company as claiming to be the owner on these void sale deeds in favor of BNP Paribas as illegal, void, and not binding on the appellants, and direct the first respondent company to deliver the said lease for cancellation of the same by executing a cancellation deed. To declare all the acts, deeds, and documents done by or executed on the basis of the 5 sale deeds dated 19/12/2008 and lease deed dated 10/11/2008, and to direct the first respondent to pay the appellants all the monies and benefits which the first respondent had received or earned. To declare that the certificates issued by the project architect dated 10/10/2008 in respect of the dispute's property are illegal and void. To grant an order of permanent injunction restraining the claimant from relying on the said certificate. To appoint an independent architect for joint inspection of the building for certifying measurement. To direct the first respondent company to complete the building as per the agreed specifications JVA and obtain completion certificate from independent architect, furnish the same. To direct first respondent company to deliver to the appellants 50% of the constructed area upon the appellant paying to the first respondent company such sum of monies as the arbitration tribunal may determine. To direct the first respondent company to return all the original documents of title pertaining to the property and to the appellants. To direct the first respondent company to deliver the original documents, etc. Then my lord's permanent injunction, and to pay the sum of money for compensation, to direct them to pay a sum of 12 crores as compensation towards loss of previous rent along with future interest. To direct, and my lords, all these are my claim monies.
Counterclaim prayers were far more. You almost exhausted the alphabet.
Because I was the person aggrieved, and let me explain to your lordships what we have here. We have concurrent findings of fact on by the arbitrator, by the learned single judge whose judgment they are relying on, and by the division bench. I'm just showing your lordships. My lords, I have just outlined from please pass this to the lords. Yeah. This is what the arbitrator finds, and this is what the single judge finds. My learned friends relying on single judge's judgment, I want to show one. Claimant should complete the construction in all respects. Claimant should complete the construction in all respect.
Where are you reading?
I'm reading from the very beginning of this note, Mark. Claimant should complete the construction in all respects. Clause 6 of the Joint Development Agreement dated 17/12/2004. I'll be taking my lord through those clauses because that's vital. Clause 6A, arbitrator says, has not been properly complied with by the claimant and admitted position that the obligation under clause 6A, B, and C have to be performed one after the other. Building was not complete and ready to operate. Finding of fact. Single judge, clause 6A not complied with. Building is not completed. Today we are producing photographs, etc. These are concurrent findings both of the section 34 code and of the learned single judge. 2. Architect has to certify that the building has been put up and completed according to the sanction plan and is fit for occupation. Clause 6 of the JDA. The certificate does not conform, this is the arbitrator, to the conditions under the JDA, but also the subsequent conduct attitude of the project architect, because he turns around and says, I am not the project architect. That letter was not shown to your lordships. Now, completely deviates, it derives as an error, my lords, in the word, it deviates the very objective of appointing the architect, Arbitrator held that Exhibit R20 certificate issued by the project architect does not fulfill the requirements as agreed upon. Now, please see what the High Court says. Project architect certificate was not validly obtained. Finding of fact of two courts. Then 83. HDFC agrees to hand over the power of attorney to the claimant on or after the handover date as defined in clause 6 of JDA. After HDFC is satisfied, the project architect has certified that the claimant has delivered the respondent's constructed area and the claimant has performed and fulfilled all the conditions stipulated in clause 6 of the JDA as per clause 7 of the escrow agreement. The bank cannot be held to be in error. This is what, my lord, has been said by the arbitrator. Cannot be held to be in error in not handing over the power of attorney to the claimant. Bank was right. High Court. Bank was right in refusing to hand over the power of attorney to the petitioner company. Then HDFC shall not be liable to hand over the power of attorney dated 29/3/2006 to the complainant, even if one or more of the conditions stipulated in the clause 6 of the JDA are not fulfilled. This is as per clause 9 of the escrow agreement. Bank cannot be held to be in error in not handing over the POA. Bank escrow agent's conduct cannot be said to be wrong. Bank was right in refusing to hand over the POA to the petitioner company. Then 6. After the claimant has delivered or deemed to have delivered the respondent's constructed areas to the respondents, the claimant shall be entitled to get a conveyance of the claimant's undivided share in the subject property. This is as per clause 31 of the JDA. Claimant executed the sale deed even without the power of attorney. Sale deeds executed were invalid. What he did, my lord, was without getting the necessary certificates under the agreement. My lord, this is not a case of equity to be decided, my lords, under 151 CPC. We are dealing with an agreement and the arbitrator is bound by it. Now the arbitrator sees that the clause says you cannot get the original power of attorney and execute the sale deed unless and until 6A, 6B, 6C and clause 7 of the escrow and 9 of the escrow is satisfied. Findings of fact, these were not satisfied. What did you go and do? You went and executed a sale deed to yourself. Without that power of attorney, you executed a sale deed to yourself.
So your prayer was for cancellation of those.
So I said cancel.
And your prayer was to direct them to complete the building. There was no prayer that the entire building should be given to us.
No, not at all.
That is what the arbitrator.
Yes, no, my lord. I'll explain. This is what is. I'm sorry, my lord. The arguments is placed does not reflect what has been done. I'm going to show, my lord. Let me tell your lordship for the arbitrator, and please see what the High Court says about the sale deed. Petitioner company to make an inadvisable move of having 5 sale deeds executed in its favor. Now, my lords, what the arbitrator does is this. He follows section 28 of the Specific Relief Act. He follows everything else. He says, look, they have come to me with a prayer to cancel the sale deeds. They are right. I have to cancel it. However, it never made any plea for any alternative relief. Your lordship knows under the Specific Relief Act, if your plea at that time was a money claim, I file a counter claim. Immediately, my lord, this is the first principle. They should have said, grant me ABC prayers, grant me specific performance, grant me a right, my lords, that I be paid X amount, an alternative of damages. Arbitrator says, my hands are tied. I've got a prayer to cancel the sale deed. I'm cancelling the sale deeds. Now, if you have any claim, you have not made a claim before me. My hands are tied. What can I do? Can he say so? You may be entitled to so many things. You may be entitled to complete and then ask for a registration again. You may be entitled to get compensation by way of money. You may be entitled for any number of things. But you have not asked me. I am powerless under the Arbitration Act to grant it. Therefore, please go ahead and file your whatever proceedings you can, appropriate proceedings to recover. The arbitrator finds that they may be entitled to something. He says, yes. But you have not prayed for anything from me. What am I to do? My lord, I'll show your lordship the order. It's, in fact, I would say it's a perfect arbitration award. Why? Because accepted finding on fact, which your lordships will not disturb under in an arbitration matter, who is that a building was not completed that was a finding of fact by both the courts under 34 also and 37. B, until completed under the terms of the agreement, they would not be entitled to get the original powers of attorney and transfer the property. C, without compliance of those conditions, they transferred the property and took it illegally. Ergo, sale deeds as executed illegally have to be cancelled. So what's the consequence? Well, the consequence would have arisen if the arbitrator didn't ask for something.
Well, the consequence would have been, they should have been told to complete the building.
From why, my lords? I ask myself why. Because they have not asked for it. My lord, I'll come to that. My lord is absolutely right if it was a civil suit.
Made by you that they should be
My
done.
lord, but that was not granted. That was not granted. And I am not agitated. They are not agitated it also saying that prayer ought to have been granted. That was not the ground of section 34. They did not say that prayer should have been granted. The point, my lord, is unfortunately, once parties decide to go for arbitration, there are advantages to arbitration, there are disadvantages. They put themselves in a straitjacket. Your lordships have put the arbitrators in a straitjacket. Your lordship's judgment has castigated arbitrators who grant reliefs not referred to them. And on issues not referred, your lordships have castigated such arbitrators. This arbitrator says, look, because you did a wrong, I had to cancel the sale deed. What is the effect of it? What have you asked me for? You asked me for nothing. If I had, let's put it this way. If the arbitrator had told that, said pay X amount, do this, do that, compensation, or you will do these following few further acts, or that now I will give you specific performance of the contract, and now validly you can take back the sale, you can demand a new sale deed. Your lordship would have said, sorry, was this ever a prayer made? Was this ever an issue? No, that was not the issue. Yes, if your lordship were hearing a civil suit, but even civil suit, your lordships have said specific, under the specific relief act, unless it's specifically prayed for, it can't be granted. Well, please, now let's see what the arbitrator has done. He says and he recognizes that, look, it's very unfortunate that it's ending with my setting aside the sale deeds. Surely you should be entitled to something. But you have not asked me, and I cannot grant it. Therefore, please file fresh proceedings on these findings and go ahead and ask for whatever relief you can ask. What does the High Court do? Please see what the High Court does in 34 and why the division bench reversed it. The High Court says the arbitrator ought to have decided more. But we, sitting in 34, cannot modify the order of the arbitrator. Since we cannot modify the order of the arbitrator, and I feel it could have done more, I'm setting aside the whole award. After agreeing that the sale deeds were wrongly executed, after agreeing with the finding, merely on the ground that the arbitrator ought to have done more, and then saying a section 34 court cannot modify the order in any way, subject to whatever your lordships have now said, but that was the law very clearly at that time. That I cannot modify the order in any way. Yes, the sale deeds were invalidly done, but the arbitrator ought to have done something else after that. He failed to do something else after that. I would have done it, but I can't modify the award. Since I can't modify the award, what do? I set aside the award in full. Patently erroneous, which is why it was reversed by the division bench. Now, please, let's come to the award itself, my lords, and see what the arbitrator said. Please first take, my lords, these clauses. These are vital clauses and very important clauses. Page 145 is the agreement. My lord, hard cases cannot make bad law. Even today, and may I say one more thing, my lord? How is my lord going to decide this? I am saying in 2010, I was given possession of the building. 2010. This inspection is coming 11. They claim they finished it. I claim I spent 5 crores to finish everything. Is my lord going to decide who's right? Is he right or am I right? We can only go on records. My learned friend says we spent so much, It's on record that he himself has said that the agreement, that the building was to cost 20 crores. 20. However, they claim to have spent 8 crores more. 28 crores. Where does this hundreds of crores come? Then their own case in the appeal is if the arbitrator's award is given effect to by them, I will have to repay 65 crores of rent which I have received. Not 65, the balance sheet show 96, but I'll take it as 65. Now, my lords, by the arbitrator's award, if the sale deed was bad, they could not have rented the property as the owner. So the consequences of that is that rent has to be paid back to me. They themselves say they collected 65 crores as rent. They themselves say they spent 28 crores on the building. Now the whole grievance before your lordship is, was the arbitrator right or wrong in relegating the parties to work out whatever remedies will follow after declaring that the sale deeds as executed in 2008 were void, invalid? Work out your remedies based on that declaration. If you feel your remedy is to claim specific performance today, claim it. If you feel your remedy is to claim damages, claim it. But it can't be, my lord, an arbitrator in one case, your lordship say, arbitrator went beyond what the reference was. Arbitrator went beyond what a prayer was made to him. Therefore, we're striking it down. In another case, arbitrator ought to have given something or not. But a law has to be constant. Did the arbitrator do something which was patently illegal as recently interpreted in by that 2025 judgment? Did the arbitrator do something patently illegal? Findings of fact, your lordship will not interfere in. Your lordship has said even if the findings in fact we don't agree with, findings in law on interpretation, we do not interfere. Here we have concurrent findings of 3 facts. Number 1, building was not completed as per the agreement. My learned friends will now produce a completion certificate. And your lordship has to come to a conclusion, yes, they completed it. What they will not show your lordship is under the guidelines. A completion certificate can be granted even when the interior work is not completed, when the interior plastering is not completed, when the interior flooring is not completed. That is the guidelines of the CMDA. It's not an occupancy certificate. It's a structure. But, my lord, are we starting a new argument before your lordship of the law? Now, am I to counter them by showing your lordship the guidelines and saying, please see, completion certificate can be granted? Just show me those. My lord, it's so extreme. I'm not just for the purpose of argument. In respect of commercial buildings, following items, please leave it. I don't waste the lordship's time. This is not an original case. Sit down. respect of commercial buildings, following items should have been completed in all respects. However, interior completion works, fixtures, flooring, and partition need not be insisted. I just show you, Lordship, the highlights of that. Electrical installations, switch boxes and fixtures not to be insisted. Sanitary and water supply installations, fixtures not to be insisted. Completion of internal plastering and flooring need not be insisted. If I'm going to now show it to my lord, is your lordship going to decide, have you satisfied? Is it complete? Is it not complete?
What was required under 6B is not the completion certificate.
Occupation, fit for the occupation.
All that you required was that the LG should have applied to the CMDA for a completion.
Sorry, my lord, but
application.
Absolutely. Absolutely.
The contractor for a completion certificate was all that was required.
Absolutely, but please read the whole clause. My lord has not read the whole clause. Please read it with me.
Yes.
My lord, kindly see 6A. What has been found is that they did not satisfy 6A and 6C. Completes the construction of the building in all respects.
Completion certificate is concerned. We are not concerned.
We are not concerned. Absolutely. That's what I'm saying.
All that he requires to do is apply for it.
That's it.
That he has applied.
I'm not concerned.
Of your
Satisfied
point that
yes,
sir. Saying that the completion certificate needs to fulfill
absolutely, my lord. Yes,
parameters.
No.
All that is.
That's why I said I'm not going
to. That is what you were addressing.
My lord. I was not addressing that as an argument. I was just going to show, my lord, are we going to be going into all this? Exactly. That's what because my learned friend is giving photographs X, Y, Z. I said, are we going to go into an original side suit before your lordships on this? Please see what they did not comply. Now I wanted to show my lord the clause.
6A is what you're saying.
6A onwards, please see. 6A. LG completes the construction of the building in all respects, including the landowner's constructed area. Please notice the next words. Fit for occupation. And the architects for the project, and that second condition. The architects of the project certified to the landowners that the building has been put up and completed according to the sanction plan and is fit for occupation. Architects do not say that at all. And
project architect does.
No, my lord. In fact, the project architect writes us a letter saying, I'm not the project architect. I'll show that, that's on record. And says, thirdly, before the my lord hasn't been shown all that. I'm going to show your lordship all this. My lord, it was a one step.
Pramod or something. What was his name?
Venkat. Yes. No, it was one step further. The arbitrator finds that the project architect never inspected the site. There's a finding of fact that the project, that's why he strikes down the project architect certificate. Why? Because he says you never visited the site.
How would he know that?
Well, it's there on evidence, I'll show you, lordship. And the High Court confirms that also. Both courts. High Court also strikes down the project architect's certificate. Both courts. That's why I said, my lord, now we'll have to say the finding of fact is wrong. We'll have to say the finding of fact that the building was not completed is wrong. The finding of fact that it was not fit for occupation is wrong. That the project architect actually visited the site. We disagree with the arbitrator. That finding is wrong. This is not a first appeal. Now, my lords, kindly see, it's not done to stop today. And the project, so it was, the finding of fact is it was not fit for occupation. If it is not fit for occupation, 6A has been violated. Now, that the building has been put up and completed, LG has applied to Chennai, that's fine. LG offers in writing to hand over the landowner's constructed area to the landowners after the conditions stipulated in 6A and 6B are fulfilled. Now, that's not done. Now, what is most important, my lord, is the next words. The date on which all the above conditions, my lord has it page 156, is hereinafter referred to as the handover date. What is important about this handover date, my lords? Can we see that upon the handover date and having complied with it, they were entitled to take from escrow the original title power of attorney and transfer the property to themselves. page 174.
Yes.
My lords, clause 37. The landowners have also this day, as my lord got there, executed another power of attorney, referred to as second power of attorney or second POA. Second POA shall be kept in escrow with Messrs. HDFC, who will deliver to LG on the said handover date, in accordance with the terms of the escrow agreement between the parties, as per the draft Annex Tier 2 as Annex Tier 5. Therefore, the escrow agreement is also part of this agreement, and therefore is also, my lords, it will be before the arbitrator. Landowners shall also register the aforesaid POA simultaneously with taking delivery of the landowner's constructed area. The said POA shall inter alia authorize, empower LG or their nominees to execute and register sale deeds in respect of LG's undivided share in the scheduled property relatable to LG's constructed area. It is specifically declared by the landowners that this power of attorney shall be irrevocable. Said second power of attorney can be acted on only after LG has delivered or is deemed to have delivered landowners' constructed area to the landowners. Manoj, my area was not delivered to me till the arbitral order in 2010. It was not delivered to me. So 6A and 6C have been violated. 37 gave them the right to transfer only after this was done. Now please see the escrow agreement. And please see 42 also at page 175. Until the said handover date, my lord, last clause, page 175. Yes. Until the said handover date, LG shall not, without the prior written consent of the landowners, assign or in any manner transfer its rights and or obligations under this agreement, including without limitation, amalgamation with any other company, transfer of shares, etc. So, my lords, the vital date under this agreement is the handover date. My lords, it is possible in a civil suit or in an Article 226, your lordships may say, look here, maybe they had not finished this. Doesn't matter. Handover date, they have not complied. But can an arbitrator do it? Once he comes to a finding of fact that the handover date had not occurred, could he have then said, but doesn't matter, I'm forgiving it. After all, they finished so much. I'm forgiving it. And doesn't matter if 37 and 42. Forget those clauses. Forget those clauses. I'm telling you now, it's perfectly okay. Your lordships will set it aside in no time. Because he, like it or not, is not bound by discretionary jurisdiction, or he doesn't have all those powers. He can only see what the. Now, my lord, please just see the situation. There's a defined handover date. Finding of fact, handover date has not come. Express clauses, till that handover date comes, you cannot take from escrow the power of attorney. You cannot transfer. Finding of fact, HDFC refused to give the power of attorney, saying it's not satisfied. That has been upheld on facts. Again, by both the forums saying HDFC was right. Then how did he transfer the land? If these are accepted facts, how did he transfer the land? That was pure and simple the question. Arbitrator says he could not have. It's invalid. I'm striking down the sale deed. And any action he did as an owner, including renting it and everything, he'll have to repay the consequences of it. But that was my prayer. Now, my lords, please see how HDFC was bound. The escrow agreement, is at page 66, I request your lordship to, of volume 3. Just give me volume. Where does it start? Page 61. Page 61 of volume 3. The rights have not been foreclosed. I want to make this very clear right now. Their rights have not been foreclosed. The arbitrator says, I can't give reliefs which you have not asked for. Please go and. So even today, they have the same rights. If they have a right, what they're claiming before your lordships, they have a right, they have a right. You be just, I be remedial. They will have that right. They will have a remedy, and the arbitrator does not foreclose them at all. I'll show you lordships. But they are finding fault with the arbitrator. Their finding was arbitrator's findings are wrong before the High Court. High Court said arbitrator's findings on facts are right. However, the arbitrator should have given you what you did not ask for. He did not give it to you. I can't give it to you. Therefore, I set aside the award in full. Now, please see page 66, clause 7 of the escrow, volume 3. HDFC agrees to hand over the said power of attorney to LG on or after the handover date as defined in clause 6 of the said JDA, after HDFC have satisfied themselves that the project has been certified, LG has delivered or deemed to have delivered the landowners. Now, my lords, admittedly, they did not deliver to me till the arbitrator's award. Arbitrator directed under my lords section 17 for them to deliver it to me. They had not even delivered it to me. LG has performed and fulfilled the conditions stipulated in clause 6 of the JDA and the said supplemental agreement.
There's something wrong with the reproduction of this clause. Because you yourself have put a
project architect. I'm sorry.
Architect.
Yeah. I didn't know. This is my learned friend's document. But anyway, one of us has.
You being all of you clubbed together.
Project architect.
Architect has.
2, 1, LG has delivered. Now, admittedly, they have not delivered. It's not the case that they have delivered. Or deemed to have delivered the landowner's constructed area. Admittedly, they did not. Let me explain to you what happened. I went before the arbitrator in 2010. 2008, they've transferred everything. 2010, I tell the arbitrator, they say, then give me back that security deposit of 4 crores, 5 crores, which I've claimed as one of my claims. So I pay that money to them and I get possession then. So admittedly, possession I got through the arbitral awards, arbitrator's order.
17.
When? In 2010. So on the date of the sale deeds, admittedly, they have not delivered me possession. That was one of the conditions. That's why I said it's not only that condition. Let me for a second say project architect perfectly good. For a second, we disagree with the factual findings of both the courts. We reverse those factual findings and we give new factual findings that the project architect certificate was gone. But still, what about the other 2 conditions? Admittedly not fulfilled. Now, please see how far this goes.
Did they write to you offering you possession
of the building? Check that. Just check it in. Immediately I will do that. Please see 3. I just want to show you 2 more clauses and I'll come back to that. 2. LG has performed and fulfilled all the conditions stipulated in clause 6 of the JDA and said supplemental agreement. Now, please see clause 9. It is expressly understood by all the parties here too, that even if 1 or more conditions stipulated in clause 6 of the JDA are not fulfilled by LG, HDFC shall not deliver the said POA. So it is rightly held that HDFC correctly did not give you the POA. And then even arbitrators got a straitjacket. What does he say? Handover date admittedly did not come.
Is there a letter of HDFC refusing to hand over?
Yes, yes.
Which page is that?
I'll show you. Page.
We'll continue after my brother's special bench is over.
I noticed that. But I was understood that for the first hearing that the special bench matter. That's what I was told. Gotcha.
Office report is already to that alert.
It needs to go before a chamber judge.
Chamber judge.
Why?
My discharge application as a registrar is there. So
Oh,
that is to be heard by chamber judge.
116, be listed before a chamber judge for appropriate directions on the application filed when it comes to this. I think it will be listed before the regular court there. Yes, Mr.
May it please. I was pointing out that the various clauses in the agreement.
Yes, sir.
Yes. Your Lordship asked me a specific question, where is the HDFC letter? There was correspondence between them and HDFC.
Right.
HDFC saying that it does not appear, they say that the conditions are not fulfilled. It appears to be a dispute. And finally, on page 246 of volume 3, they write a harsh letter to HDFC. That letter is not on record, but it's referred to. At 246 is HDFC's letter dated 30th December 2008. Please note, my lords, that they had done the sale on 19th December, even prior to them making a demand. Release of original power of attorney held under escrow arrangement. So they don't have it even on that date. With utmost surprise, we have received your letter dated 20th December 2008. It is rather unfortunate that you have written this letter with highly unreasonable assumptions with regard to HDFC's conduct under the escrow arrangement. In the context, we write to inform you that no such actions and discussions have happened as falsely assumed and alleged by you in your above dated letter. In fact, you should know that as a reasonable institution, we are performing duties of an escrow agent in accordance and within the purview of the escrow agreement. Further, we reiterate that we are within our rights to make necessary inquiries that we deem fit under the escrow arrangement, and it is within the scope of the documents that has been signed in that regard. Therefore, we strongly resent about your allegation made in your letter and confirm that it is false, baseless, and far from truth. We do not expect such irresponsible averments from a reputed company. In the meantime, we have received a letter from the Menon family, signed by his so-and-so, enclosing a letter from architects Messrs. Nataraj and Venkat, wherein we find that they have now denied that they are the project architects. I'm going to show my lord. This was not shown to your lordship. Your lordship said, where is that letter? I've located that. As defined and understood in joint development agreement and the escrow agreement. In view of this, question of releasing the original power of attorney at this stage does not arise, as the project architect certification, which is a prime condition for release of power of attorney, is not satisfied. This is what the escrow agent felt. They say that their report was given. That certificate, they said, the escrow agent said it's not right. Maybe, my lord, I'll take it to the extreme. Escrow agent was wrong. I was wrong that it was not completed. What is their remedy? They can immediately file an action and say, give it to me. Please, you can't take the law into your own hands and enter into this sale deed to yourself without the power of attorney. Well, they had a cause of action, all right. I'm taking the case at its best. That unreasonably it was not being returned by HDFC. Unreasonably, we were saying it was incomplete. Unreasonably. They had a remedy. They filed immediately for specific performance. They do whatever it is. There's an arbitrator who is to be appointed if that is the thing. You don't take the law in your own hands. Now, my lords, please see. It appears there are conflicting claims made by the parties concerned with the JD and various other issues raised by them. Hence, there is need to obtain a letter jointly signed by both the parties towards the settlement of issues, confirmation of satisfaction. Nothing wrong in what the escrow agent says. All right, I'm unreasonably not giving it. Take your remedy. Don't take law into your hands. Now, my lords, kindly see this letter from the so-called architect, project architect. Your lordship will find it at page. No. The letter 272, is it? No. 219. Sorry, 219. Thank you. 219.
Same body.
Same body. When I raise an objection and say, how did you give that certificate? This is their reply at 219. The certificate my learned friend showed, which said that this is a tentative certificate and it will be complete once XYZ is done. Even the certificate they're relying on says, once all this is done, it will be complete and fit for occupation. So it's not a completion certificate under the agreement. So when I take umbrage at such a certificate, please see what they say, 23/12/2008. Yeah, and this is what HDFC refers to in its letter. I received your registered letter. My apologies for the delayed reply. I've written to them as early as on 13/11/2008. Let me first place on record that my client is Lancor Holdings Limited, insofar as the building is concerned. Said appointment clearly specifies my role in the project. I do not have any interest in your agreements with Lancor Holdings. That these agreements entrust responsibility on me is your view, with which I cannot agree, since I'm not a party to those arrangements. My responsibility is to provide architectural services to my client. I do not appreciate your oblique reference and rules to regulations of the Architect Council of India. It's out of context. On my certificate given to my client, it speaks for itself. It is not my job to check whether the TLEB supplies current or whether the WSSB supplies water to the convenience of the occupants. Again, it is not my job to find out whether the equipments and systems installed in the building are working properly. On your surprise or otherwise receiving a letter dated 5/11/2008, I have to again declare my complete indifference. I cannot imagine how you would believe that I should be concerned about your power of attorney, escrow agent, whether Lancor Limited would rely on our certificate, etc. If you have issues with your builder, feel free to take it up, but do not involve me. Please note I will not withdraw the certificate. You may intimate this to your brother. Well,
your agreement doesn't mention a project architect though?
Well, it does.
Don't you name this agency?
No, I don't think the agency is named. Just check whether it's named. I don't want to give a wrong answer. But this is shocking. And please now see what was worse is the examination of their witness. It's on record before the in the award. I just extract that for your lordships. Just check whether the project. I just check that and get back to my lord. Let me not waste time. Please take. Yes. Come to the examination. Now let's kindly see. On this issue,
page 13, page 13 of volume.
Is that so?
Volume Venkat Architect.
Volume?
Volume 3, page 13.
Page 13.
13, 1-3.
1-3 at volume 3.
13, volume 3.
Paragraph 1.
Shall be retained as architects. Yes. But please see the reply. I'm not your architect. I'm not the architect of the project. My client is the other side. Now, no wonder that certificate is struck down, and I'll show your lordship why. This same man, your lordship saw the letter. HDFC has this letter from such an architect and said, I can't treat this as a completion certificate by a project architect when he himself disclaims responsibility. He says, it's not my job to check. Not my job to check whether it's working. Not my job.
10/10/2008 certificate that we gave.
Yeah, now let's read that.
Who is it addressed to?
And please see that. 103. Same volume 3. To whomsoever it may concern. And then he turns around and says, these people are my clients. I gave them what they wanted. 10/10/2008, to whomsoever it may concern. This is to certify Lancor Holdings has constructed the so-and-so, etc. No objection certificates issued by so-and-so, that is fire and rescue, has been given. We understand from Lancor that 2 numbers of generators are installed at the site, will be operational, therefore not operational. Lancor Holding has incorporated all the specifications. In many cases, they've exceeded the same. We also understand from Lancor Holdings Limited that they made an application to Chennai Metropolitan Developments for completion certificate, same as under process. On date of this letter certificate, corporation so-and-so have given their compliance, no objection certificate, saying the above said building has been completed. Building is fit for occupation as soon as the Tamil Nadu Electricity Board gives power connection. and the water and sewerage board gives the necessary connection. So how can this be a completion certificate? And please now see in the second letter, please compare this now, my lords, with the same letter I read to your lordship. And what is very shocking in that letter, which you will find at 219, how can such a person's certificate be accepted as gospel truth? First of all, he starts at 219. My client is Lancor Holdings.
This other letter that he refers to, 5/11/2008, is that also on the record?
My lord,
on your surprise or otherwise of receiving a letter dated 5/11/2008 from Lancor Holdings.
Lancor Holdings.
Is that letter also there?
My lord, I think that must have been, I don't, no, because even the certificate is only, yes, Lancor must have sent me the certificate and
This is the covering letter.
That's the covering letter, Mr. My lord, but please let me show you what all he says. My client is Lancor Holdings. First of all, that is not for the project for you. I do not have any interest in your agreements with Lancor. These agreements entrust responsibility on me is your view, with which I cannot agree. Since I am not a party to those arrangements, my responsibility is to provide architectural services to my client, who Lancor. I do not appreciate. Now, over the page, on my certificate given to my client, it speaks for itself.
Do we also have your letter to this architect?
I'll get it. I'll just
Page 127.
127.
127.
I was seeing that.
127:13. I address it to him. In fact, my lord, this sheds a lot of light why he replies like that. Page 127.
Yes.
In continuation of my letter dated so and so and copied to you and to the escrow agent HDFC, I'm writing this letter. As already pointed out by me in my letter, your role as project architect of the project is a very important one in the sense that our agreements entered into. So first of all, he says, Lancor is my client. So that's why in paragraph 2, he says, Lancor is my client and I'm not concerned with your agreement. As a professional architect, you'll agree with me when I say rules and regulations framed by Architects Council impose an obligation on every architect to satisfy himself thoroughly before he certifies a project as having been completed fully, as per the agreed specifications, as being fit for human occupation. In your certificate given to Lancor, you have not given an unqualified and unconditional certificate, even though you have issued the said certificate in your capacity as architect of the project. Your certificate is based on the information gathered from Lancor Holdings. Regarding the installation of generators, submission of letter to Chennai, you have also qualified your certificate by saying that the building is fit for occupation as soon as the electricity board and sewerage board give the necessary connections. It is needless to point out provision for electricity, water and sewerage to the project will have to meet the specifications mentioned in the joint development agreement. Project architect will have to satisfy himself that the electricity board and the water sewerage board are supplying enough electricity and water as has been agreed to. Architect will also have to satisfy himself that the equipment and systems provided by the developer are working efficiently. There are no leakage of electricity, water and sewage in the building. Because, my lord, one of the inspection reports says, what was not read, my learned friend left that part out inadvertently probably, is, my lords, they say that there is leakage of water in the basement where the electrical connections are.
We've read that.
So whatever it is, it was not completed. Fit for occupation. An architect can satisfy himself about these aspects only upon the electricity board, water sewerage board giving their respective connections. Without professionally satisfying yourself about these vital aspects of the project, which also concern the very safety of men and materials, you have chosen to certify that the building is fit for occupation. I'm surprised to receive a letter dated 5/11 from Lancor, where they stated that they are completing the formalities in order to get the power of attorney executed by us in favor of Lancor, and which is lying with the escrow agent. The said power of attorney empowers Lancor to convey to themselves or to their nominees 50% undivided share. Legal consequence of the delivery of the power of attorney by escrow is a serious one. It is clear from the context in which Lancor Holdings have written their letter that they are relying upon your certificate dated 10/10, which is a fact, in order to claim before HDFC that they fulfill their obligations under the various agreements. So that's why HDFC says, I don't consider this an unqualified completion certificate. And HDFC takes note of two things. One, they do not consider that certificate as being the certificate under the agreement. And two, they say, look at the subsequent letter. Please note that Lancor Holdings cannot seek to rely on your certificate before completion. I'm constrained to say that the certificate you have issued is premature. They're relying on the certificate dated 10/10/2008 and are claiming the project is complete in all respects and that you have certified it to be so. Circumstances, I request you to withdraw your certificate. Now, please see again, my lords, page 219. In response to this, they say, let me first place on record that my client is Lancor, because I started by saying you're the architect for the project. Insofar as the building, the said appointment clearly specifies my role in the project. I do not have any interest in your agreements with Lancor. That these agreements entrust responsibility on me is your view, with which I cannot agree. Since I am not a party to those arrangements, my responsibility is to provide architectural services to my client. I do not appreciate your oblique reference. Now, over the page, on my certificate given to my client, it speaks for itself. It is not my job to check whether the TNEP supplies current. Then what is a completion certificate? Supplies current. I cannot imagine how you would believe that I should be concerned about your power of attorney, escrow agent, whether Lancor Holdings would rely on our certificate, etc. If you have issues with your builder, feel free to take it up, but do not involve me. Well, what more can I say? This is what the architect himself says. It's not my job to check all this. Now, what compounds it is, please see the examination of their witness in, my lords, which has been part of the award, at page 263 of volume 2. My lords, page 257. All the reasons why the arbitrator is not willing to accept this as a completion certificate. Page 257. Meaning there has been complete application of mind to it, consideration, and he's come to a conclusion. I am inclined to hold that Exhibit R20 does not fulfill the requirements as agreed upon for the following reasons. The certificate can be issued only after the building is fit for occupation. On the very face of the certificate, the building cannot be said to be fit for occupation in the absence of power, water, and sewerage connections. Even the generators will become operational in future and not as on the date of the certificate. Such being the case, there is absolutely no need of justification to have issued a certificate as on 10/10/2008 when all the works were not complete so as to be fit for occupation. In terms of clause 6A, the certification by the power of attorney by the project architect is intended for and has been addressed to the landowners. But Exhibit R20 has not been addressed to the landowners, addressed in general terms to whomsoever it may concern. Not even a copy is marked to the respondent, but sent only to the claimant, which is against the spirit of clause 6A, which requires that the PA has to certify to the landowners. This reason alone need not be termed or stated to be fatal, if it had been at least issued otherwise on a proper basis, but would be certainly a reason which would throw a cloud on the acceptability of the certificate, considered along with the other circumstances surrounding R20 and the subsequent stand taken by both the claimant and the project architect. Following circumstances will also disclose that the stand of the project architect is not tenable. Under R23, the respondents have commented upon the incomplete nature of the certificate, and the copy of the same has been marked to the project architect. Under Exhibit R28, dated 13/11, respondent informed the project architect that the certificate issued by them was premature. A belated reply is sent by the project architect, dated 23/12, stating that client was only the claimant. This stand is certainly not correct in view of the terms of the JDA as well as the supplemental agreement. Not being satisfied with such an erroneous contention, project architect goes further to say they did not have any interest in the agreements between parties. No responsibility can be cast upon them. That what transpired with the escrow agent on the was not a matter of concern to them. And if there was any issue, the respondent may take them up with the claimant and the project architect cannot be involved. And that the project architect stands by the certificate. The various stands thus taken by the project architect are totally untenable having regard to the terms of the agreement. Project architect has a very major and salient role to play, and it is a common agreed party with certain obligations and duties to be performed as an impartial and independent expert who is required to issue a certificate of paramount importance in the context of mutual obligations and rights. The project architect, pretending ignorance of the terms of the agreement, disowning any responsibilities, calling themselves as answerable only to the claimant, goes against a very basic purpose or spirit in the matter of appointing a project architect. Project architect is a person who has to hold both parties at even scale, and his certificate requires to be issued in a judicial manner. Terming the claimant as the only client and the project architect had nothing to do with the terms, raise the question then, what are the functions of the project architect in their understanding? It is unimaginable that the project architect would have issued the certificate quite oblivious of the agreement between the parties. Agreements between the parties are the source of appointment and scope of the functions, and he cannot claim ignorance. Now, my lords, kindly see, it is also pertinent to note, project architect in the reply refers to an appointment issued by the claimant, specifying the role of the project architect. No date is mentioned nor a copy is enclosed, nor has the document been filed by the claimant. Totally inconceivable to believe that such an appointment could have been made before the agreement between the parties. Project architect would have entered into and discharged his obligation. Stand thus taken is completely violative of their role. I add to this also, my lords, what I showed your lordships, that he says it's not my job to inspect as to its working. Now, please see further. Answers given by the claimant in the cross-examination clearly established that the project architect was not only aware of the JDA, but also the escrow agreement. Therefore, stand of the project architect pleading ignorance is completely untenable. Therefore, I have no doubt in my mind that Exhibit R20 cannot be accepted as a valid certificate as contemplated under 6A. Then, my lords, kindly see at page 263, paragraph 62. Apart from the conclusions, so this is discussed till 263, my lords, as to why he's not happy with that, why he can't consider it a completion certificate for the purpose of clause 6A. Apart from the conclusions which I have arrived at as above, on a consideration of the documentary materials, it is unfortunate that the evasive manner in which CW1, the claimant, had answered questions do not in any manner help the claimant which are detailed below. On the question of the validity of the architect's certificate as inspection, this is what the witness has to say. Did you forward minutes of such inspection meeting with the respondents at any point of time? I do not remember. Would you be able to produce such forwards if you are given time to verify records? Yes, it's not produced. Did the architect visit the site in August or September? I do not remember. Did the architect ever point out any deficiency in your work? Yes. Did he point out any such deficiency in September? I do not remember. Did the architect participate in the demarcation of terrace? He drew the plans for the terrace, there's no demarcated. When did you complete the landscaping? October, November 2008. Was the architect personally present at the site any time between 7th and 9th October? I do not remember. Has the architect issued any certificate of demarcation of terrace area? I do not know. Was there any minutes drawn before the architect issued the certificate of 10/10/2008? I do not remember. Did you request the architect to be present with you in October before seeking the certificate? We wrote to the architect to inspect the premises. Have you produced that letter? I do not remember. It's not produced. Did you request or call upon the respondents to be present for the inspection prior to 10/10/2008? I do not remember. I put it to you that your architect issued a certificate without inspecting the property before issuing such certificate. No comments. No comments. Well, I asked myself, what is the arbitrator to do except to say, look, I'm sorry, I don't consider this a proper project architect's certificate. What else could the arbitrator have done? Then, my lord, was the lift operational before the architect issued the certificate? I do not remember. Then, my lords, kindly see 269. Last question. 269, last question on this page. As per clause 7 of the escrow agreement, who has to certify that the claimant has performed and fulfilled all the conditions stipulated at clause 6 of the said JDA and the said supplementary agreement? Nobody needs to certify.
Which question are you reading?
Question number 269.
Question number?
Yes, at page 266. The very last question on that page.
266.
As per clause 7, who has to certify that the claimant has performed and fulfilled all the conditions stipulated?
The questions are not reproduced.
No.
Because we are jumping from 190.
Yes. But he's taking these questions with regard to the architect, project architect certificate. That's what he is referring to, because the claimant witness obviously gave evidence on all the subject, all the points. But please see this, that condition stipulated at clause 6 of the JDA and the said supplemental agreement, nobody needs to certify. Clause 6, then your lordship will see to 304. Did the architect visit the site before issuing the certificate at R20? I have no knowledge as to whether the architect visited the place or not. That's why the architect says it's not my job to check all that. The above are samples of unsatisfactory answers of CW1 as regards the role of the project architect, and the fact that the project architect does not appear to be visiting the building at all for inspection. To cap it all, the following answer puts a last nail on the quality or neutrality of the architect and motive for the claimant. I put it to you that at your behest and in order to help the claimant, Nataraj and Venkat have issued R20. He issued the certificate R20 at our behest. The certificate helped us to complete one set of formalities. It is unfortunate that architect support should be treated and reduced to the level of a mere formality to enable the claimant to achieve a certain goal, and not for the intended purpose for what it was meant. Architect being an independent person who could be relied upon by the landowners to whom he is mainly responsible, to certify to the landowners that the building has been put up and completed according to the sanctioned plan. As regards the requirement which should make the building ready for occupation, answers of CW1 do not help the case of the claimant. And some of his answers are extracted below. In all respects means that whatever is mentioned ought to have been in the building. Whatever items are mentioned in clause 4, like 50% constructed area, open area, must have been there and it should be completed in all respects. Yes. When by the word all other facilities complete in all respects, you mean availability of electric water, water and sewerage connection. We have to go by the... When the witness is required to give a specific answer, the witness states that he stands by his earlier answer. What are the important considerations? Built up area per floor, number of floors, etc., etc. He goes on, method of firefighting, etc. Question 244. Were all these available on 29/7/2008? They were not available on that date. Please specify what were available on the date. As on so-and-so, item number so-and-so were not available. All the others were available. Please see Exhibit R21, that is your letter of 1110. Item 1, the work mentioned at this 2 and 2.1 and Roman 2 were not completed. Yes. As of 10:10, the architect certificate, the entrance lobby and the lift lobby were not completed. I do not remember. Please see Exhibit R22. On the date of R22, dated 2010, electricity, water, sewerage have not been provided to the building. I agree.
Yes.
Malad, I ask myself the question. Is this sufficient evidence that exists of having been considered for the arbitrator to say, look, this certificate is not worth the paper it's written on? He may be wrong, your lordship may have a different view, but we are not in first appeal. You may well have a different view and say, no, I think despite all this, I would have still said all right. Well, that's not open under the Arbitration Act. But can we say this is so perverse that no reasonable man could come to the conclusion that this certificate is really not worth it and is not the certificate under 6A? Is it possible that a reasonable man could come to such a conclusion? That's all is the test. So, my lords, the condition of architect certificate was also not available, which they had to give. The building fit for occupation. The arbitrator goes into all that. We are not today before your lordships on a question, are they minor defects, are they major defects? The claim is not, my lord, a claim for damages on account of major defects, minor defects. That is not the claim before your lordships. There might be a minor defect, but if it's not fit for occupation, then they could not have transferred the property to themselves. That is the only question before your lordship. There is no other question. But let me say to the most minor defect. Let me say, look, subsequently they can get the water sewerage. Subsequently they can get this. See, they did this in 2011. What is the position of the building today? Did they repair the building after 2010? Let me answer yes to every one of those questions. They did a brilliant job after 2011. They made a most phenomenal building. They completed it. They did it. But the question is, was their transfer to themselves permissible under the agreement? If they had a dispute on that day, they should have referred that dispute, asked for specific performance, asked for a direction, then pointed out and said, look, these are minor defects. Please don't, because of these minor defects, hold up the release of the power of attorney. Please, because of that, do not hold up my being entitled to transfer the property. But you can't take law into your hands. You can't turn around and say, forget the agreement. I'm going to transfer it to myself because according to me, I have completed. According to me, there are minor deficiencies. I heard all the arguments being said, these are minor, these are minor, these are minor. That was the argument. I kept hearing the word minor so many times. Minor, major is not for consideration except in an action for damages before your lordship. Question is, was it completely ready for occupation? The word is not completion certificate. Apply for completion certificate. Building must be fit for occupation. On the date they transfer the sale deed, they transfer the property. Was it fit for occupation on that date? That's a short question. Maybe, I'll put it like this, maybe the flat was completely ready, but no doors had been put in. Maybe the cistern in the toilet had not been put in. Was it fit for occupation? Your lordship may say minor. After all, they could have done the door in 2 days. But till that 2 days, they could not have done what they did. Now, my lords will kindly see detailed findings that in any event it was not fit for occupation. Please don't go into the findings as to whether, oh, these are securable, these are small, these are big. That's not the case before your lordships. Now, my lords, kindly see at page 272, paragraph 68.
Yes.
I am unable to agree with that. My lords, kindly see paragraph. Can I just start from 67? Paragraph 67, page 271.
Yes.
One other aspect of the defense by the claimant appears to be that what was contemplated under the JDE was only filing of the application for the completion certificate in order to fix the handover date, and that the actual receipt of completion certificate was not contemplated. Therefore, according to the claimant, it follows that water and sewerage and electrical connection cannot be obtained without the completion certificate. Hence, the landowners cannot believe that such requirement ought to have been completed at the time of handover date. Shocking, my lords, when they say, is it fit for occupation if I don't have electricity and water and sewerage? It was further contended that the expression fit for occupation had different connotation with reference to the residential complexes, commercial complexes. I am unable to agree with the contentions. The terms of JDA, supplemental agreements, escrow agreement had already been dealt with in a detailed manner and found that the requirements in the clause 6 of JDA have not been properly complied with, and it is not necessary to repeat them again. The distinction which is sought to be placed between the requirements for commercial and non-commercial complexes is neither acceptable nor can override the practical issues in a complex intended to be a software technology park being described as fit for occupation without the facility of power. But it's a software park without the facility of power, water and drainage connection. Specific terms of the agreement between the parties cannot be ignored. Mere submission of completion certificate must have a nexus with the actual facts. That's why your lordship said we are not concerned with the completion certificate. The only fact for submission of completion certificate merely for the purpose of fulfilling requirements as formality is not sufficient. Right from and inclusive of the submission of the certificate of the architect, the requirements have not been complied in terms of the agreement. Several defects attached to the certificate of the architect have already been pointed out. Besides the architect himself disowning his status as project architect, ignoring his obligations and was to issue and not the manner in which he chose to issue it. Further, at one stage, CW1 himself has taken the stand that the qualified manner in which the architect was issued with reference to power, water and sanitary connection, question number 317, was not as per the agreement and that the architect has stated so himself. Therefore, the attempt on the part of the claimant to dilute or ignore the various requirements under the JDA as being complied with or to be ignored by the mere fact of submission of the application for the completion certificate before CMDA cannot be sustained. Section 52 of the Contract Act mandates when the order in which reciprocal promises are to be performed is fixed by the contract, they shall be performed only in that order. They need not be performed in that order only when the contract does not expressly fix the order of performance or in that order which the nature of transaction requires. In this case, the order of performance has been clearly fixed and demarcated. Hence, second alternative does not arise for consideration. Even ignoring the same, there is no acceptable material by any independent evidence that in the case of commercial complexes, such basic requirements are not necessary. For the above reasons, it is also not possible to assume that a fictional date of handing over, when specific requirements are stipulated under the agreement between the parties, found not properly complied with. But the same argument was continued before, my lords, saying they were minor. Same argument is continued here. The architect, my lord, so far as the arbitrator is concerned, he says, sorry, the agreement is clear. I'm here to arbitrate on the agreement. One of the grounds for setting aside an award is if I go beyond the agreement. If assume that the arbitrator said, I know the agreement says so. However, I will override that and accept this. That will have to be set aside under 34 as going against the very terms of the agreement. A further contention which was raised by the Learned Counsel for claimant is that issue of architect certificate would arise only if no completion certificate had been obtained. Submission is made only to buttress the fact that the architect certificate being defective. Though this submission need not be taken as an admission of the architect certificate is defective and not being valid, yet this submission does not stand to the scrutiny of the strict terms and conditions of clause 6. Such a stand is contrary to the specific terms of the agreement. As stated earlier and is laid down under section 52, the terms of the contract have to be strictly complied with and interpreted not in a manner to suit the convenience of or the self-serving purpose interpretation of the clauses by one of the parties. Hence, on the above issues, I am inclined to hold as follows. Issues 2, 5, and 6 are answered against the claimant, found that the claimant has not complied with the terms of clause 6 of the JDA, and hence found that they have not discharged their obligations regarding the completion of the building construction as required under the JDA and the supplemental agreements. Various clauses under the supplemental agreements regarding the satisfactory completion of the building are consequential to clause 6, hence found to be not properly complied with. Date fixed by the claimant 2010 cannot be said to be either as the handover date or as deemed handover date. So also the respondents were not obliged to respond to the communication set by the claimants regarding the completion of the building or the handover date. Nor can the respondent be found fault with for not responding to the communication from the claimant about the completion of the building or landowner's constructed area being ready for occupation. Issue number 3 is answered and held that the project certificate dated so and so is invalid. Now, just give me the part about unsatisfactory. That's the next one. Issue number 4, the requirement to appoint an architect afresh was raised more as an interlocutory prayer by the respondent as a corollary to their contention that certificate of the project architect was invalid. Hence, it would be necessary to appoint an architect that put afresh to note the stage and quality of the construction. This is pending during the arbitration. It was found unnecessary and instead Vedu Associates engineers were appointed as independent engineer in this arbitral proceeding. Report has been filed by them. Madam, that is in 2011. 2008 is when this entire thing took place and they transferred it. And my lord, I had occupied it from 2010. So when I occupied it in 2010 in 6 months, it is my case that I did much of the completion work because I had occupied it. Whether that's right, whether it's wrong, yes or no, my lord, that's a matter for the arbitrator to decide. The appointment of a fresh architect was declined by me mainly on the ground that a new architect to be appointed nearly 3 years after the completion of construction will not be relevant for the purpose of issuing the architect certificate at the said distance of time. Therefore, I directed the appointment of independent engineer will be able to inspect the building, render a report which should be sufficient to deal with the alleged infirmities. Therefore, though the prayer under this issue for appointment of independent architect is declined, considering that independent engineer came to be appointed only with reference to the prayer, be appropriate to deal with the engineer's report. As regards the alleged unsatisfactory nature of the construction, report with the annexures photographs also shows sufficient light on the nature of construction, whether the construction was satisfactorily completed. And we're talking 2011 now, my lord. 2011, not 2008. In terms of the agreement justify the claim of the claimant regarding the completion handover. Report was only marked in evidence, but also the two engineers who had conducted the inspection after due notice. Prior to the report, joint inspection will be conducted. Though several defects have been pointed out by the generator flow-wise, some of the defects can be ignored, treated as marginal in a massive construction. There will always be a need to set right certain deficiencies here and there. As regards certain defects, remedial measures were undertaken by the claimant. Please pause, Manoj. When were these remedial measures taken? Subsequently, not on the date of the transfer by the same deeds. That itself, Manoj, may I point this out? The very fact that the claimants themselves say we had to take remedial measures means it was not fit for occupation. To the report gives flow-wise defective incomplete works. Annexure 2 deals with the remarks of the claimant on the report. Admittedly, certain rectification works have been carried out. Finally, under Annexure 3, the report deals with item-wise points. So and so show that several defects, grievances which have been pointed out have been subsequently rectified during the final inspection. I'm also inclined to hold that such defects which are marginable and tolerable to a great extent have been rectified by the claimant as pointed out by the engineers, though not to the utmost satisfaction of the respondent. In a major construction, there are bound to be certain defects like seepages here and there, broken glass panes which have to be ignored. Engineers themselves have mentioned them as tolerable. However, I have to point out a few defects which are major and bound to be taken note of. Staircase, the following are the findings. Then your lordships will kindly see that, yes, page 280, basement. We're now again talking 2011, Malak. This is dealt with as 0.7.
The report does not say anywhere that you claim to have undertaken any rectification.
No.
Didn't do anything.
It doesn't say anything. They say rectification action has been
Everything
taken.
was done by them.
Taken.
No, you had said earlier that most of it was done by you.
That's my case.
But when have you said it when
Ignore it. No, I'm saying please ignore it. What I wanted to point out, my lord, is something different. We are talking about a 2011 stage when I myself had taken possession in 2010 of my portion. Once I had taken possession of my portion in 2010, there was no question of them rectifying my portion. I'm sorry. I don't
took place. Inspection is
in
of
11.
the entire building.
In 11.
Entire building. But when the inspection took place and you participated,
yes,
you never said to the engineer that this part of it.
No, not at all.
On the other hand, the report indicates,
not at all.
The finding of the arbitrator indicates that they undertook the works throughout, but not to your satisfaction.
That he's referring to our complaints earlier. But it's
the rectification. Rectification 2011.
So I want to point
not
that
earlier.
And what I want to point out,
therefore, even your portion after 2010, you never seem to have claimed that you did any rectification.
No, I didn't, my lord, because I'll explain why. Let me just explain. Parties are in dispute. We are before an arbitrator.
You just told us now that you did more.
I'm explaining why I'm saying so much. I'm explaining my reason for saying so. Parties are in dispute. We are before an arbitrator. I want possession of my portion. When I want possession of my portion, I have to move an application. I am then given possession of my portion. The last thing any reasonable person will do is to tell them, you please come back, take possession and rectify. And the last thing they will do is to rectify. I'm just saying from that angle I was saying, my lord. Because once I take possession, I'm not going to give them possession again to do any rectification work in my lord is right. But anyway, that's of no significance, and I'll explain why.
Very good.
But let me take it. They rectified it brilliantly. Everything perfect. But what was the position in December 2008? That is the only question. That's why I said, my lord, somewhere the hoods and the trees, my learned friends are losing, because they're going on about minor defect, not going into clause 6, not going into the contraction. Now please see basement, page 280. This is dealt with as 0.7 at page 5 of the annexure, dealing with the remarks of the respondent about water seepage in the floor, many places, including the electric room. And it is a serious safety, I don't know what it is, result. The following is the finding in the engineer's report. This is a serious defect, as any water stagnation in the panel room could lead to serious consequences, including explosion. This needs careful consideration. It was noticed that the builder has provided the following remedial measures. Now again, remedial. This is subsequent. Providing extra base concrete, thereby raising the floor level. A sump is being constructed in the basement to collect the seepage water. Pumping arrangements with submersible pump to pump it out. Waterproofing of the flooring to prevent. We did not notice any water stagnation in the flooring of the panel room at the time of our inspection, though there was wetness on the floor. However, it is felt that there could be seepage and collection of water in the panel room flooring during rains, when groundwater pressure will be quite high. This risk could have been avoided had proper waterproofing been provided below the basement and side walls up to ground level at the beginning itself. Under the present circumstances, recommended to provide surface proofing, so not the interior waterproofing, but surface proofing in the basement floor and walls by utilizing services specialists to prevent formation of moisture. Proper ventilation should be ensured. This should be done, etc. Now, my lords, kindly see paragraph 79.
Yes.
I have produced the claimant's objections to the engineer's report as well as heard submission of both sides. As regards the defects pointed out in the engineer's report and mentioned above, I am inclined to observe that the objections of the claimant are not sustainable. Claimant has attempted only to state what efforts they have taken in the said context, which is not answer to the actual state of affairs. As regards staircase, quality of finish, quality of tiles, apart from detailing the work done by them and stating it was not the practice to replace entire staircase, claimant has not yet offered any satisfactory answer to the positive finding of the engineer. Defect in context was not consistent with the standard and nature of the building described as state-of-the-art building. Engineers rejected and held there was no force in the contention of the building. The granite slabs were in good condition. Response of the claimant is that it is not a practice to replace staircases for the sake of few chip steps is not acceptable. Nor the remarks of the engineer on the quality of tiles, granite slabs have been properly counted. The only manner in which the claimant could have effectively countered the positive findings was to have examined a reputed specialist engineer on their behalf, providing an opportunity to respond to cross-examination. Remarks on the absence of a canopy, which had found place in the approved drawing, is sought to be lightly brushed aside by the claimant by observing that the architect felt that it was not required. It is for the respondent to say whether an agreed pattern of the building as in the approved drawing, which is part of the contract, is necessary or not, and not for the project architect who had also chosen to deny status as the project architect and was not answerable. I am therefore inclined to hold that the above major defects in the construction found as late as March 2011 throw considerable light on the controversy as to whether the building was properly completed for being handed over to the landowner. Hence, the defects pointed out are relevant to also support the contention to the contract. Also, the findings have rendered whether there was a valid compliance with the requirements to effect a valid handover, whether the certificate of the architect was proper and valid. Then, my lords, so-and-so independent engineers were cross-examined in detail on behalf of the claimant. I find their evidence has not been discredited in any manner. Also perused the objections on all issues, questions of which adverse comments have been made in the report and photographs filed by the engineer. Both witnesses have categorically and firmly given their answers relating to gaps in structural placing, improper waterproofing, etc. My lords, I submit all this is irrelevant. What the condition was in 2011 is irrelevant for the main question, which is, was it complete as per clause 6A and fit for occupation on the date that they took on to themselves to consider as the handover date and took on themselves to say 6A, BC is compliant? Or is there a question mark on it? That's enough. All I have to show, my lord, is there was a question mark. If there was a question mark, findings of fact have been rendered answering that question mark. And unless your lordships find that finding is so perverse, an interference, my lord, under section 34 or 37 or 136 would not be called for. Because today, when my lords are sitting in 136, and that I'm going to also dilate on when I refer to the modification, or I say Article 142 argument. When your lordships are sitting under 136 in an arbitration act, your lordships are judging it from the aspect of the arbitration act. 141. In fact, what did your lordship say there? You said it can be read into the award, although not expressly stated that this was to be paid. Therefore, under 142, we are making the payment. We are reading into the award. Not that I can modify it by saying, no, I don't agree with this part of the award under 142. In this particular case, your lordships are sitting as the final court in an arbitration proceeding and are as governed by the Arbitration Act as the arbitrator is. It is not because as a Supreme Court, you're not governed by the Arbitration Act or the rules which you'd apply in 34. So it's the same which applies, my lords, when your lordships consider. Now, my only question to your lordship, which I put to myself, is this. Was there a question mark as to whether the building was fit for occupation on that date? Answer, yes, there was a question mark. Has that question mark been answered on facts? Yes, it has been. Is that answer so unreasonable that your lordship say, what do you mean? There's no doubt, there's no question mark. It was complete and fit for occupation on that date. That's the finding my lord will have to come to. That on the record, it was fit for occupation on that date. If it was not fit for occupation on that date, and your lordships cannot say it was fit for occupation on that date with certainty, then my lords would not interfere with the award. And then what the award did was absolutely right. So the award held two things. One, the project architect certificate was not there because they held it to be invalid and said this is not the certificate contemplated under clause 6. Number two, held that it was not completed as fit for occupation on the date that they took on themselves to treat it as handed over without, and the escrow agent says, I will not allow it, and act against the escrow and sell the property to themselves.